what you want?
Hello, this petition is filed against the rejection order of the departmental estate
M.A. Charlie. Learned
Preferred by
counsel
the
matters sent to
petitioner.
John. Why?
Hello, the entire inquiry proceeding is vitiated the rules of Assam Services rules of 1964. The entire proceeding is vitiated and violated the rule 9
Is
of
this the matter where? Yes, I remember this matter. Yes. You were there on that day,
Yes.
or your senior was there?
Hello, his health condition is not good.
Okay, very well.
Already decided, Lordship, page 103.
103, I've seen it. But the thing is, what do you do? In fact, what mistake they have done is they should have challenged it out there in the writ appeal itself.
Lordship.
Along with the writ appeal, they should have challenged that order there.
Yes.
Now it is part mill. How can this court now decide this aspect? Fellow will issue notice. I can't help you out there otherwise.
Hello, Honorable Division Bench already given us liberty to file
I've
this.
seen it. I've seen it. In fact, what should have been done by you at that point of time before the division bench is that saying that you will file a writ petition separately and that writ petition should be taken with the writ appeal. But that has not been taken. Now tell me, when the coordinate bench has already decided on merits that you don't have a right, then the appeal order becomes clear.
The grounds of the Assam Services.
So here the only limited question, therefore, here this court can decide is as to whether the appellate authority, while passing the order, did not exercise the jurisdiction properly.
Yes, sir.
That's the only thing.
That's only all.
But Mr.
M.A. Charlie. M.A. Charlie.
Mentally, the learned counsel for the petitioner, Mr. S. Roy appears for
1, 2, 3, 4.
1, 2, 3, 4. Why you are making number 5? Why you are making him a party? The inquiry officer.
Because he has violated he has inquired the inquiry report not properly submitted.
So what? Are you alleging malafide against? Anyways, you have made the things complicated. You want to make it further complicated. Why do you want to make him a part in by person?
Because he has not inquired properly inquired.
So properly not inquired is a different thing, but does it, you have to make him a party for that by name. Why do you have to make him a party? Is it there any allegation of malafide against him?
Well, he may be struck.
Mr. So-and-so and Mr. So-and-so. The learned counsel for the petitioner submits that he does not want to proceed against the respondent number 5, taking into account that there is no allegation of malafide against him. Accordingly, the name of the respondent number 5 is struck. Issue notice making it returnable by 4 weeks. Extra copies of the petition be served upon the learned counsel, Mr. S.S. Roy, within 3 days.
Anna 2.
Always not.
Yes, have you paid the deficit court fee?
Yes, sir.
Then I did. You paid? But Mr. Ada Gupta, the learned counsel, senior counsel, assisted by so. Yes, Mr. E. Agarwal, you appear for?
A.K. Singh for all the respondents, my lord, FCA.
Appears on behalf of all the respondents. Issue notice making it returnable by 4 weeks. As the respondents are duly represented by the learned counsel for the Mr. B. Agarwal, BK
BK
Agarwal,
Singh, ma'am.
BK Singh, BK Singh. Extra copies of the petition be served upon him within 3 days. It has also been brought to the attention of the court that the petitioner have also paid the deficit for fee, the details of which have been furnished during the course of the hearing. The state is kept on record and marked with the letter X.
And number 3,
Please, your lordship.
Hmm.
Lordship, matter relates to non-payment of arrears salary. Lordship, the petitioner was working as an assistant teacher of Lalutila LP School.
Hmm.
And he was put under suspension, Lordship, by order dated 1/4/2016.
Hmm.
However, after inquiry, nothing was found against him.
Hmm.
And he was again reinstated to service. Lordship, Annexure 5, reinstatement order. Initially, he was allowed to get a
So
salary.
you have been
50% of
treated
the
as,
salary.
that period has been treated as for duty.
On duty, Lordship.
And
that
as
period
such, you are
has been-
entitled to the remaining part of the
remaining part of
salary,
the salary, Lordship.
which has not been paid.
No, Lordship.
That is your case.
Yes, Lordship.
Third, Miss, your name?
S. N. Gupta.
S.N. Gupta, the learned counsel, appearing on behalf of the petitioner. Mr. N.J. Katani appears for the report number 1,
3,
3,
5 and 6.
1, 3, 5, and 6. Mr. Arpa Putari appears for the respondent number 2 and 4. What is this Director of Finance Department?
There is no post called director. It may be deleted. It may be deleted. There is no post called director. ma'am.
By respondent number 3, the respondent number 2. Mr. Arpa Putari further submits that there is no post by the nomenclature of Director of Finance Department. Taking into account the same, the name of the respondent number 4 is deleted. The registry shall make necessary correction in the cost title accordingly. Issue notice making it returnable on when? This year?
Yes.
Financial year?
Yes, ma'am.
Okay, making it returnable on 31st of March 2023. The case of the petitioner herein, and as the respondents are duly represented, extra copies of the same be furnished during the course of the day. Madam, during the course of the
Yes,
day,
Lordship.
the case of the petitioner herein is that the petitioner was put under suspension by an order dated 1/4/2016 by the Deputy Inspector of Schools, Karimganj. During this period, the petitioner was paid his substance, his or her,
Yes,
his
Lordship.
subsistence allowance. Subsequent thereto, by an order dated 11/3/2021, the Deputy Inspector of Schools, on account of insufficient evidence, have dropped the proceedings against the petitioner and have treated the petitioner and treated the suspension period from 1/4/2016 to 15/2/2021 as on duty. It is therefore the case of the petitioner that during this period, the petitioner is entitled to the salary after deduction of the subsistence allowance, which have not been paid by the respondent authorities, and as such, the instant writ petition has been filed. The learned counsel appearing on behalf of the respondent, more particularly the counsel appearing for the elementary education
Elementary.
department, shall apprise the court on the next returnable date as to when the said payment of the area salary would be made to the petitioner. Pending disposal of the pending notice, the respondents are at liberty to make the payment of the area salary to the petitioner.
Obliged.
Item number 4.
Yes, madam,
Petitioner is casual worker lordship. since
not
March-
senior. Once I have taken this bench,
lordship,
yes.
I do
What is
not have
this?
much matters in this.
Huh?
bench. I do not have much matters in this. Lordship knows civil bench one with regular bench.
Oh, you want that minimum of the scale of pay?
Since March 1993, he is lordship working and his lordship.
You have been working since when?
March
When is the appointment order?
There is no appointment order lordship, but
Then-
it is reflected in Annexure 7 also. It is Annexure 7, page 41. That is a letter
Therefore,
from principal
enrolling my
chief
name
conservator.
in my.
Second paragraph.
What is your name?
Ali Haider Borfi.
Pradeep Hospital, California. You have moved the repetition earlier? No.
No, no.
My lord, after Upendas, my lord, Forest Department had constituted a committee under an officer, and that committee prescribed certain pro forma. So a person who was left out, he had to submit on form.
Hmm.
So my lord, let me have some instructions whether this person qualifies those yardsticks or not.
Okay. But it is the case that he has been appointed prior to 1/4/1993.
Yes, worship, March 99.
Mrs. R. Chaudhary, the learned counsel appearing on behalf of the petitioner. Mr. D. Gogoi appears on behalf of all the respondents.
All the sort of.
All the respondents.
Two is there, my lord, two finances.
Appears on behalf of respondent number 1, 3, 4, and 5. Mr. R. Babudari appears for the respondent number 2. Issue notice making it returnable on 3rd of April,
Well,
2023. As the respondents are duly represented, extra copies be served upon the respective councils within 3 days. The case of the petitioner in brief is that the petitioner have been working as a casual worker on daily basis under the Karimganj Forest Division since 1993. The petitioner claims that he is entitled to be treated similarly to
Page
the
36.
petitioners in the case of Upen Das and 835 others as directed by the division bench in the case of State of Assam versus Upen Das and 835 others, read appeal 45/2014, dated 8/6/2017. The petitioner therefore claims that the petitioner, being a casual worker working in non-sanctioned post, for a period of more than 10 years prior to 1/8/2017, is therefore entitled to the payment of minimum of pay scale which have not been given by the respondent authorities for which the instant writ petition has been filed. The learned counsel appearing on behalf of the Forest Department shall on the returnable date apprise this court as to why the petitioner have not been given the similar treatment in terms with the judgment and order dated 8/6/2017 in writ appeal number 45/2000. Still
45 of 2014.
2014,
Yes, sir. Read appeal 45 of 2014.
writ 45/2014.
Apply.
5,
Happy the lordship. The matter relates to lordship non-payment of compassionate allowance.
Non-payment of,
Compassionate allowance. Lord.
what is that?
That is lordship. If
Hmm?
somebody lordship was removed from the service,
Directing they have to
suspended.
release the compassionate allowance in favor upon him. What is this compassionate allowance business?
compassionate allowance lordship. If somebody lordship doing service, he was removed from the service. Thereafter, he do the service for more than 20 years, lordship. Then he is entitled for the compassionate allowance.
As per?
As per salient features, lordship. of life
Huh?
insurance. Salient feature, lordship, I kindly say, is salient features
Of,
of lordship, Life Insurance Corporation of India, employees pension.
you have enclosed it here.
Lordship,
You have enclosed.
enclosed.
Where is it?
No, I am not enclosed, lordship.
Why?
But lordship, in the representation itself,
The
lordship,
backbone of the case is that,
that
and without the backbone, you have put it.
lordship, I kindly-
Why your petition? That means your petition doesn't have a spine.
Fine, lordship.
It has a spine.
Representation is there, lordship. In that
Representation is there,
reflected.
but why are you not bringing it? We'll have it on some other day. We'll have it on today is Wednesday. We'll have it on Thursday, Friday. Bring it by way of an additional affidavit. The learned counsel appearing on behalf of the petitioner submits that he would like to file an additional affidavit bringing on record the
Salient features.
salient features of what?
Salient features of lordship. The salient features of the Life Insurance Corporation of India, employees pension rules 1995.
Sorry, I couldn't help it. An
The
additional
second
affidavit
page, lordship,
bringing
I
on
kindly say,
record
last paragraph, lord.
the salient features of the Life Insurance Corporation of India bracket employees pension rules 1995. This is the matter again on Monday. We fix it on 2023. I can't read you, huh?
and number 6,
Yes, Mr. Prakash.
Yes, Lordship, this is the second round of litigation, my lord, and they have rejected the claim for the financial upgradation of the petitioner, my lord, on the same ground against which they have filed the affidavit, my lord. Let me take the Lordship to page number 51.
Amend the OM so and so and of the Iman in the light of the established legal position.
The OM, my lord, has derived from the notification dated 17/3/2017, which is the issue of the finance
Notices to go. He
department.
has challenged the OM.
Huh?
He has challenged the OM. So notices to go. We have to respond, my lord. Other than this,
Okay.
there is nothing.
But the impugn order which they have issued, my lord, in the contesting before this honorable court on the same ground, the order has passed, my lord, in my favor after contest, and the impugn order is issued on the basis of same ground again. That cannot be, my lord. They have assailed this ground before this
Let
honorable court.
us see which order you are saying.
My lord, impugn order, my lord, page 55.
21/9/2022 is the order.
Yes, 55, my lord.
What is the direction?
They have
In the light of this court is of the concern that the case of the petitioner may be considered for grant of financial provision and benefit provisionally by the government by taking into consideration the provision of MSA, more particularly fund in remark topic payment. Consider the case of the petitioner by extending the financial benefit provisionally. And where is the impugn order?
impugn order, my lord, page 55 is the rejection part. Therefore,
And there is another case. Why?
Yes, my lord. He
another
in a single writ petition, he has challenged two orders. One is the speaking order, other is the OM.
You have means where will the petitioner go? You keep on rejecting him. That is why earlier you was filing individual petitions. Now you are Once they consolidate
In
it,
spite of my lord having the established legal.
otherwise
procedure.
tomorrow you will raise on the ground that he has not raised, and as such, the provision of order 2, rule 2 will apply.
Yes. They've rejected my lord, applying the provision of that,
So you are saying that the impugn order which
Yes.
have been passed
Yes.
is in violation to the orders passed by this court?
partially, my lord.
Partial.
Yeah.
Okay, then I think we should issue the notice.
A notice, to go, my lord, notice.
That is what I said, my lord. The notice has to go.
No, I was just considering whether a notice with a strict direction should go or
Yes, Lordship.
purely notice which should.
My lord,
Strict direction should
only
go.
notice, my lord, because we also have to respond, my lord. At the end of the day, my lord will decide the matter.
Already, my lord, the
As
settled position is there.
Mr. B. Purkasted, the learned counsel appearing on behalf of the petitioner. Mr. Ardhor appears for the respond number 1 and 2.
1 and 2, my lord.
Issue notice making it returnable by have it after vacation
My lord.
on 21st of April.
My lord.
As the respondent is duly represented, extra copies of the writ petition be served upon him within 3 days. The petitioner herein is aggrieved by the orders dated, the office memorandum dated 14/8/2018 and 8/2/2023. Further to that, the petitioner is also aggrieved by the order dated 6/2/2023 passed by the respondent number 2, which as per the petitioner is in contrary to the directions passed by this court in WPC number
6010, my lord.
6010/2019. The learned counsel appearing on behalf of the respondents is directed to obtain instructions in this matter and file their affidavit on or before the returnable date without fail, taking into account that this is the second round of litigation.
Obliged, Lordship.
7,
Yes, Mr. T. Gokoi.
One of the petitioner before Lordship is an assistant retired teacher, madam. During the course of her employment, while a certain excess payment was bestowed upon her, madam, without her fault. Lordship will go to page 14. Annexure, this is the original.
Excess payment for what?
Salary, madam. The salary that
Wrong
Even-
fixation.
wrong fixation, madam. And
You are
she-
retired?
I have retired, madam. But during that, madam, I was directed to return back the money.
You have
I
returned?
retired. I returned.
You have returned?
I returned. So now I seek, madam, that may be given back to me, madam, because
And now they have fixed your
yes.
pension as per the correct
yes,
fixation
correct. Yes,
that has been done.
yes, madam. That has been
The
done.
only remaining is,
That money, madam.
yes,
Yes, I'll open instruction.
what instruction? You pay interest? You want to pay interest, will you obtain instruction?
No, he has already returned the money, my lord.
So get the, pay him back.
Yes, my lord, we'll definitely, my lord, but
You see, the matter comes sometime later on. After 2 months, 3 months, then what will happen to him? He's entitled to interest from the date of the notice, at least for me.
that is why I'm not praying for a notice, my lord, but I'm just praying for a
No,
instruction, my lord.
this court does not disturb the learned counsel for the respondents without a notice. Let us see that the order by which the director of pension have caused the difficulty. Yes,
My lord, 14, my lord, goes. Then, my lord,
yes.
page 14, my lord, seen that. it is
By
not-
which it has been said that he
Oversight.
would not, if the wishes to withdraw her pension to an authorized agent, and now your PPO has been done.
PPO has been done, my lord.
Now, where is that problem which has been created by the director of pension?
The director is not causing any problem, my lord. This,
Who has caused the problem?
my lord, initially, my lord, it was wrong fixation by the education department.
Understood,
Yes,
they
madam.
pay you.
Yes.
Problem arises only at the time of retirement.
Yes,
When you go for a pension, the director of pension or the accountant general catches it.
my lord.
And then says that unless you make it, remove the deficiency,
Yes.
your pension would not be paid.
My lord, will kindly come to page 19. My lord.
Okay.
That wrong fixation was condoned, my lord. ROP was amended.
Ah,
Page 19.
yes. Tell me.
Page 19, my lord. Corresponding pages, page, my lord. 33, my lord. Page 33.
So
There's a-
you say that there was nothing wrong.
No, that overdrawal was, my lord, that overpayment was condoned by this amendment, my lord.
Then where?
33, my lord, there's a column called 36. I fall within that pay band now, my lord. After my retirement.
24,180.
My lord,
Rate
60,
pay of 3,300.
36 or
now it-
64,160 rupees.
Huh?
36, my lord. Page 33, column number 36.
Yeah, 24,180 with rate pay of 3,300.
Yes, my lord. 64,160 and 55,640.
Pay band is 55,460.
Yes, my lord.
Now what happened?
So, my lord, since this was amended, that I have been now brought in after my retirement, this was amended. So my that question which they claimed that was oversight, that is amended. So I returned the money. So I need that money back now. Because this recovery was not due to my fault, my lord. Even Lordship will kindly see page 44, my lord.
Respect to I have the honor to. So these have been given by the headmaster.
Yes, my lord.
Then
And then, my lord, now since that part has been condoned, I have been brought into, my lord, say after my retirement. So the payment which I've made, returned back, my lord, that money I need back. That's all, my lord. And similar seated persons, my lord, page 54, they had approached this court earlier, my lord.
who?
Similar citizen persons, my lord. Page 54, my lord.
Hello. But Mr. He wants a notice. Let's issue notice. Normally this court disposes the matter on the first day itself.
That's up to your lordship. Apart from that, my lord, the petition of your lordship is, my lord, very terminally ill, my lord. She is suffering from this medical documents I have annexed, my lord, dementia and Parkinson's, my lord. So considering that aspect, my lord, will
Who
this petitioner, my
is suffering from?
lord, Parkinson's, my lord,
And
and kind of, my lord, seizure. I have been told dementia not correct, but my lord, this medical document says
dementia, and you want on an affidavit of a dementia patient?
no, my lord, not dementia.
Huh?
It's, my lord, not dementia. It's, my lord, seizure disorder, Parkinson, my lord.
Better now.
So that aspect, my lordship will consider. Apart from that, I don't have any. If he comes with instruction, my lord.
When?
No short notice. Within this financial year, my lord.
Yes, within this financial year. At Mr. T. Gokoi, the learned counsel appearing on behalf of the petitioner. Mr. PJ, Mr. NJ Khatuni appears on behalf of the respondent numbers 1, 3,
1, 3, 5.
5. Mr. B. Soikia appears for the respondent number 4. And Mr. Arbor Putari appears for respondent number 2 and 6.
2 and 6.
2 and 6. Issue notice making it returnable on 29th of March 2023. As the respondents are duly represented, extra copies of the petition be served during the course of the day. The learned counsel appearing on behalf of the petitioner had submitted that on account of wrong fixation of pay, for which the petitioner had no fault. The petitioner under duress had to pay the amount of rupees. How much?
1,44,000, 1,000, 133.
1,44,133 on 4/3/2019. The learned counsel appearing on behalf of the petitioner have further submitted that this is a case which is squarely covered by the judgment of the Supreme Court in the case of Rafiq Masi, State of Punjab versus Rafiq Masi, Whitewasher Shupra, reported in so and so. Itu asay no word for it. And he further submits that the case that the respondent authorities at the time of retirement of the petitioner, after retirement of the petitioner, have sought to make the recovery which is otherwise impermissible and iniquitous. He further submits that this is not a case where there is any undertaking being given by the petitioner or there is any fraud or collusion which had resulted in the wrong fixation of the pay. In that view of the matter, the respondents, this court upon hearing the learned counsel for the petitioner therefore directs the respondents to apprise this court on the next returnable date as to why the petitioner is not entitled to the refund of the amount of rupees 1,44,130. There is also one office memorandum, 2019,
But that I don't have.
Yes, yes.
which is not permissible. You have asked for interest, no?
No. I keep it plain and
Yes,
simple,
Mr.
my
B.
lord.
Chakraborty helps you.
Office memorandum dated 14 June 2019.
The learned counsel for the petitioner has also, during the course of the hearing, instruction of hearing also submitted that there is an office memorandum of the government of Assam dated 14/2/2019, which have been adopted by the government on the basis of the judgment rendered in the case of Rafiq Masi Supra. And as such, the imposition so made upon the recovery so made from the petitioner is on the face of it not permissible.
Always.
Always, my lord.
Anno 8,
Yes, what do you want?
May I please, Your Lordship? This is the case for a quantum of gratuity.
Huh?
Quantum of gratuity of Assam Financial Corporation. Yes. Now they are paying in terms of a trust with LIC 7 lakhs as gratuity. But already Assam state government has adopted it as per the Gratuity Act 1972, adopted as 15 lakhs. But Financial Corporation is a corporation under the government of Assam.
Why you
In this
making all
regard,
these
similarly
people a party?
situated, for similarly situated, page number 59, from 59,
Okay, what is your name?
this honorable court has passed an judgment. in
Mr.
order-
Counsel, your name?
G. Pathak.
Deepathak. That is the Deepathak, the learned counsel appearing on behalf of the petitioner. Who appears for the public enterprise? Anybody? Public enterprise?
I am for one lord.
One, that is what public enterprise.
Anjan, sorry lordship, I am not there. It's A Kolita, Anjan Kolita is.
For respondent number 1, my lord, Mr. Anjan Kolita is the standing counsel.
None appears for the respondent number 1.
I am appearing for R2, my lord.
Mr. R. Pujari appears for the respondent number 2. Next. The learned counsel for the petitioner has submitted that the Department of Public Enterprise is represented by a counsel, has a standing counsel before the High Court, in the High Court. who may be permitted to be, no, who be, and the petitioner be allowed to serve copies upon him. Nah, itu pisotnya. Issue notice returnable by 4 weeks. The learned counsel for the petitioner has submitted that there is a count that the Department of Public Enterprise is represented by, has a standing counsel. And he may be permitted to serve extra copies of the writ petition upon him. As regards the respondent number 2, as it, Mr. Extra copies of the writ petition be served upon Mr. R. Pujari. In respect to the respondent number 3, 4, 5, and 6, steps be taken by way of registered as well as usual.
Item number 9.
May I plead the lordship? My lord, this is a covered case, my lord.
Oh.
My lord, they kindly turn to page, my lord. 10, no, my lord, this is 42, my lord. By which, my lord, the honorable.
What are you asking for?
My lord, the arrear salary for the same period for which, my lord, the order was passed in this case, my lord. Because in earlier occasion, my lord, this petitioner and myself, my lord, with the same both, my lord, and we prayed that, my lord, our without taking any undertaking and insisting on to give any undertaking that not to claim for the arrear salary. So accordingly, honorable court has issued an order that not to insist on them. Accordingly, we are allowed to join. And after that, my lord, another my lord writ petitioner who has, my lord, the part of my in earlier occasion, he filed a writ petition claiming the arrear, my lord, that was allowed. And after that, my lord, I also prayed that as the both were similar, my lord, putting, so I should be given the same benefit. Now the department is saying that no, we have to pass agreeing a separate order from this court. That is the earlier lordship before.
No, tell me one thing.
My lord.
Whether you were regularized, when? When?
My lord,
And where is the question of you being a stipendiary teacher?
my lord, that was in initial appointment, my lord.
And then,
My lord, there is a condition that if on the moment we clear the, my lord, junior basic, then we will be allowed to get
very well, then,
regular scale. So in spite of that, whenever we clear that was not given, then we approach, my lord, before lordship by number of, my lord, writ petitions, and the writ petition are some more than 100. So in that case, my lord, while, my lord, we are directed to keep the benefit and to pay the salary if we are working regularly. Then, my lord, we are trying to be terminated. Then again, we came before court lordship.
trying to be terminated means how?
That
Are you
was, my
not
lord,
government
decision-
servant?
Decision taken by the government, my lord, at the time. Then, my lord, we all approach again before lordship. Then we are state and give the protection. By this time, my lord, government has come with a decision on the basis of the Manohan Commission that is some irregular.
So you
appointment.
come under the excess teachers.
No, my lord. Yes, there's irregular, but subsequently our subject was regularized, my lord. Kindly
Understood, but you were an excess teacher.
irregular, we have found irregular.
Your appointment initially was irregular.
Yes.
Now, you have been now given the excess, you come within the ambit of excess teacher.
At that time, my lord.
Exactly. And thereby the government had regularized you.
Regularized, my lord.
Now what has happened?
But after the time regularized, my lord, there is a, my lord, condition was put that my lord, we are not claiming the back wages.
Then,
So then we before lordship.
ah,
This, my lord, present petitioner, another petitioner, the Mr. Kuch, my lord, I rely upon that.
and then,
And court has given that no, this is a, my lord, the unconscious clause. This insists upon be given. So this is the order, my lord. Kindly come to page annexure 6 of my petition, my lord. Annexure page 34. Kindly be back forward, my lord. Backward. by which pilot that was given the benefit that we are not going to be insisted to give the undertaking. Secondly, our services.
So this is only for a period from 8 to 1996 to 31/12/2003. Your
Yes,
claim of
yes,
salary,
yes,
area
yes.
salary.
Yes, my lord. Yes. It is for the period, my lord, from the date of.
Where is Mr. Arba Pujari?
Passing of the similar basic in date of the similar passing of junior basic till my lord the date of my lord regular.
So in your appointment order has been interfered with? No, Mr. Borpujari, this is a case of excess teacher. Now, while appointing them as excess teacher, there was a condition that the earlier period of area salary shall not be taken into account. Some condition. Well, let's see where is the condition.
Condition on annex of 5.
Annex of 5.
5 at page 33.
This was done in
Condition number
2002. The services of the teachers will be adjusted with immediate effect after the vacant posts have been erected. The teachers will have to give up undertaking at the time that they will not claim area salary for the first service and they have rendered. However, their period of past service will be counted for the purpose of pension benefit only. The benefits of such teachers shall be adjusted against vacant posts if available in the same. In case of non-availability of the vacant post, the teachers shall have to be adjusted against vacant posts available in the nearby. Now, where is your subsequent appointment?
Yes, my lord.
Subsequent appointment? When you have been regularized?
Yes, my annexer 8, my lord.
Huh?
Annexer 8, page 38.
Irregular teacher is subject to and he or she shall retire. The regulation will be prospective by giving all other services on the date. Teacher concerned will be given regular scale of pay of 20. Will have to submit joining report. This was done on, what is the date?
It was my last in 11 to 2004. Next page, my lord. 39 page.
11 to 2004. Okay. Now the regularization shall be prospective effect by giving all other service benefits from the date of joining.
That is so far my lord, area salary that was not undertaking was from me and I never give the undertaking. So accordingly, my lord, I approached before Lordship claiming that area salary. So Lordship also, my lord, please to pass the order that I am entitled for the area salary. And accordingly, my lord, that Dharmeswar Kuch, my lord, has given the all area salary, my lord, now. He have paid, my lord. After filing a contempt case, that everything has been released, my lord. So I said that, my lord, is similar thing, my lord, in my case also. So I should be similarly treated. If I forgo the, my lord, claim, there is a different thing. But whenever I am not.
But why have you approached in 2023?
My lord, whenever the order was passed, my lord, then I file a, my lord, representation before the authority, my lord.
Representation, can it enlarge the period from 2003 till 2023?
No, my lord, this is from 20, my lord.
Huh?
Date of my lord representation.
No.
Which one, my lord?
Why you were all along silent from 2003?
No, my lord, 3, my lord, not 3, my lord. I came before Lordship, my lord, by filing another. This is Annexa 5, Annexa 6, my lord.
Yes. What does it say?
I, my lord, challenging this, my lord, unconscious.
Have to
On the
give
basis
up
of that, my lord, I was
taking up
allowed to join
adjustment.
without
The
giving
clause is
this
unfair,
undertaking.
unwritten, and hence that as an interim measure it is ordered that. Now what happened to this matter?
I was allowed to doubt, my lord.
Now understood. What happened to this petition?
This petition was disposed of, my lord.
Where?
This was on, my lord,
Because this is an interim order.
But this was, my lord, after the disposal, my lord.
Where?
The order it is right now, it is not
This
available.
order clause is unfair and unreasonable, and hence as an interim measure.
Yes, my lord. Then subsequently, my lord, is another petition that was filed in Annex 13, my lord.
Right?
Page 42.
No, you are not the person. That was filed in
I was
2005.
in this disposition, I was not the person, but I was in the person in the earlier on the basis of which my lord the claiming was made.
Understood, but what happened to that petition?
That petition, my lord, after interim, my lord, they probably
You
my lord,
forgot.
dispose of, my lord.
How?
It is not clear, my lord, but this is order, my lord. is
How can
available.
an undertaking, if it is given or not, or under an interim order, it can be done. But anyways, that has been done if you're defending. But we have to know what has happened to that, whether the petition survived or dismissed.
But
Because if it has been dismissed, then your interim order goes.
no, my lord, not this, my lord.
No, then somewhere something has happened,
No, my lord.
or is it lying in some file?
But after that, my lord, they that was complied also, my lord. They without giving.
Did you
any
withdraw?
My lord, this is the, my lord, ordered on the
No,
basis of-
this can't be a final order because it is said as an interim. Isn't it, Mr. Borbujari?
Yes,
As I understand, isn't this an interim order?
yes. And my lord,
But this
I-
so far, my lord, the nature of the order is passed, my lord. It is seems to be, my lord, final because the entire matter is
So
decided.
what
It is
happened to this? Let us see the file.
unconcise- Unconcise
Okay.
and unfair, it has been
Well,
decided.
issue notice, Mr. Mohanto. This court is not otherwise
No,
satisfied
no, my
with
lord, I am
the.
not on that, my lord. Lordship
I'll
will
issue
issue
notice on that
and
and I'll ask
instruction will
this
be
out.
obtained,
I'll ask the registry to tag along this writ petition. I think that is whether it is disposed of or not, we don't know.
And by this time, my
Because
lord,
another thing, Mr. You have to explain as to why you have, let us assume that the thing has been removed by by this court. But why you waited for all this while? Now, how do you take care of a division bench judgment wherein it says that a person is not entitled to beyond 3 years?
but at the same time, my lord, the Supreme Court also saying that since something is passed, my lord, the same benefits would be given to the similarly all the participants. I am on that footing, my lord, the bank amalgamation case, my lord. It's saying that if some, I may not come before the lordship at the time, but if some benefit is given, that should be equally treated to the all, my lord.
No. Why did you waited to file a representation in 2020? This is for the period from 1996 to 2003.
That is
Then
that is fall on
we
my-
are in 2023 when you have filed the writ petition.
that is a fall on my part, but
Then why should the, because there is a division bench judgment to that
that
effect.
is true, my lord, but equality, my lord, that should be treated to all, my lord. Article 14, my lord, if something is given to me in the person of that order and that benefit, that should equally be treated to me also. This is my prayer, my lord. I'm not nothing on that. And department also not saying that I am not entitled, they're saying that no, a separate order I have to be, my lord, top report. But that was not the report. But the instruction will be
My lord,
obtained, my
by
lord, that is
virtue of this interim order, only, my lord, this honorable court has, my lord, interfered with that clause of undertaking. Meaning thereby, my lord, that a state cannot insist a petitioner to give undertaking. So his entitlement is there. Now he has to, my lord, to be vigil to seek redressal of
Yeah,
his
because
demand.
this is from 96 to
Yes.
2003.
And the division
If
bench,
some, if another coordinate bench passes an order without looking into the division bench order by which it has been said that 3 years is the limit out there
yes,
for areas, Harendranath Kolita.
and it is the fallout of the Supreme Court decision in Tarsem Singh. Tarsem Singh also reiterates the same
Then
position, my lord.
why should this court, anyways, I'll issue notice.
My lord, so far, my lord, another, my lord, case, my lord, the contractor's case, my lord, my lord, that was all compilation of the cases, the order was passed by honorable justice, my lord, Iqbal Ansari, my lord. Where it is, my lord, says, my lord, the state cannot take the plea, my lord, and limitation of 3 years in case of the money, my lord. Money, my lord, state cannot take the plea. In other ways, my lord, that will come, but state being a, my lord, good employer and advantage, but they cannot, my lord, claim the waive of all the claims that will be covered in the other cases. So
Mr.
far, this is
Counsel,
my
Mr.
right, my
Counsel,
lord.
the state cannot take a plea. There has been many judgments, many cases also recently in Calcutta High Court also, it has been mentioned
Yes, my lord.
that the state cannot take the plea. But one thing is that do you have this court is going to issue a writ, a mandamus. Do you have an enforceable right as of now? That is another aspect which have not been taken into consideration. That is why, although it is always held that there is a state cannot take the plea of unjust enrichment or whatever may be, the state cannot take the plea. But if this court has to issue a mandamus, there has to be an enforceable
Yes, my
right.
lord. But one thing, my lord, so far my lord, the payment is concerned, my lord, the rightly or wrongly, whatever may be, my lord, whenever I discharge some duties to the magistrate.
After 25 years, 35 years, if you
lord.
come, do they have to keep
No.
accounts?
My lord, at that time, my lord, it is my fault, I could not come along with that petitioner, but the
You were so vigilant to come immediately with that introduction of that condition
my lord,
that
But-
you could
but-
very well do.
but
And then after all these years, when another person has come in 2015 and got an order, now you wake up and say
Lordship
this.
has the all right to, my lord, scrutinize the entire.
Let us not spoil the judicial time on this
Yeah,
discussion
petitioner
any
is
further.
before-
There are
Lordship is,
there are corresponding
PT
decisions
teacher,
of
my
the
lord.
Honorable Supreme Court also that fence sitters should not be allowed to take any benefit. He is a fence sitter, he is voting. There are decisions, my lord. Anyway,
so
I'm
far,
not
my
a-
lord,
Heard Mr. P. Mohanto, the learned counsel appearing on
And-
behalf of the
Lordship, my lord,
petitioner.
one thing, my lord, so far the other cases concerned is going that is disposed of, my lord. Order is
I'll
not-
ask for the records. Yes, heard Mr. P. Mohanto, the learned counsel appearing on behalf of the petitioner, Mr. Babuja, you are,
No, my lord,
no, finance is not a party.
not a party.
Except finance, he can appear for all.
Huh?
Except finance, my lord, he can appear.
No, finance is not a party.
Finance is not part.
There the problem will arise. When I pass the order, how can it be complied with?
My lord, then I will, my lord, take a plea, my lord, I'll impeach this, my lord. This one, as
We'll
a-
make the finance a party.
I file a
At the
property.
outside, Mr. N.J. Khatoni appears for the Elementary Education Department. The learned counsel for the petitioner submits that inadvertently the finance department has not been made party. And in order that an effective read can be issued, the finance department is required to be made a party. Taking into account that this is a matter pertaining to a claim of area salary, and a too technical approach would not be, no. Taking into account the submission made by the learned counsel for the petitioner, this court impledes the commissioner and secretary to the government of Assam in the finance department, having his office at Dispur, Guwahati 781006 as the respondent number 5 to the instant writ petition. The registry shall make necessary correction of the records. Mr. Arbor Pujari, the learned counsel appearing on behalf of the finance department, accepts notice on behalf of the respondent number 5, newly impleaded respondent number 5, and Mr. N.J. Khatuni accepts notice on behalf of the respondent numbers 1 to 4. Issue notice making it returnable on 21st of April 2023. The registry is also further directed to tag the records of WPC number 276/2003 along with the instant writ petition on the next returnable date.
Pass up.
10.
My lord, may I pay, my lord, letter name of HC Finance being shown in the conflict, madam.
The question of maintainability of the writ petition shall be considered on the next date. The registry shall also indicate the names of the counsels representing the respondents in the corpus.
I'm so obliged.
Item number 10.
May it please your lordship.
Yes.
The petitioner is a widow. She is agreed file recovery of an amount of 3,42,474.
You are a widow.
Yes, your lordship.
What do you want?
Your lordship, an amount of 3,42,474 has been recovered from me on account of the death cum retirement gratuity payable for the service rendered by my deceased husband, your lordship. He had expired on 11/9/2021, whereas his scheduled date of retirement was 38/2022, which is less than your lordship 1 year before the his date of retirement.
Where is that order of the pension order? Where?
Your lordship will find it at page number 24.
Yes. 23? Bawal be accepted. Yes, what?
Your lordship, the death cum retirement gratuity payable was 11,59,980,
Hmm.
whereas a deduction of 3,42,474 has been made, your lord,
Why?
on account of overpayments made during the service of the petitioner's husband, your lord.
Where is it?
Your lordship, at page number 24, where the amount rupees 3,42,474 is mentioned, your lordship.
Hmm.
Just adjacent to that is overpayment of pay and allowances, your lordship. That is the reason.
Understood, but why?
The recovery, your lord.
Yes, why that
Lordship,
amount?
from the information I
Have
have
you issued notice? Mr.
Lordship, I've made a statement that it was due to wrong fixation of pay, your lordship.
Where is it? We have to get that instruction, Mr. Earlier in the earlier matter, where I was about to dispose of, the other side said no. Here I don't want, but the other. You are saying this. But the thing is, whatever may be, you see, as it is not clear whether it is on the question of wrong fixation or is it in the case of any other thing, it would be without notice, it would not be possible. Your name?
Yes, they, your lord.
Heard Mr. S. Day, the learned counsel appearing on behalf of the petitioner. Mr.
Lordship, I
A.
am for
Gugoi appears for
1 and 5, Lordship.
respondent number 1 and 5. Mr.
2 and
P.
3,
Chakraborty appears for respondent number 2
and
and
3.
3. Mr. Arbo Pujari appears for respondent number 4. Issue notice making it returnable on 21st of April 2023. As the respondent numbers 1 to 5 are represented by the respective counsels, extra copies of the writ petition be served upon him during the within 3 days. Steps upon the respondent number 6 by way of registered as well as usual within 3 days. You want to take steps by way of custody upon this paper?
Registered, your lord. I'll take it to registered.
No, that's. The case of the petitioner herein is the petitioner is the widow of one Ramoni Mohan Soikia, since deceased. Record of since deceased. The said late Ramoni Mohan Soikia joined services, joined as what?
He had joined, your lordship,
You don't know.
as a faculty member, your lordship.
He was
retired as
a
an
joint as
assistant
a Lordship lecturer, Lordship, but now it is a designated assistant professor.
Was late Ramoni Mohan Soikia joined as a lecturer at Dhemaji Commerce College on 1/7/1999. Prior to his retirement on 30/8/2022, prior to his retirement, which was scheduled on 30/8/2022, he unfortunately expired on 11/9/2021. The case of the petitioner herein that the petitioner, although have been granted the pension by the respondent authorities, but while making payment of the DCRG, an amount of rupees 3,42,474 has been deducted on the ground of overpayment of pay and allowances. The petitioner on inquiry could come to learn that the same has been done on the ground of wrong fixation of the pay of her husband, claiming the said amount of rupees 3,42,474. The petitioner has approached this court under Article 226 of the Constitution. The respondent, more particularly the respondent number 1,
Lordship, here Lordship, SG and respondent number 6 have to reply. Pension, we have no rules nowadays. Lordship. Nowadays, Lordship, in matter of pension and pensionary benefit, Lordship.
I'm not on pensioner. What is there wrong fixation or
Wrong
not?
fixation,
Wrong fixation, you will do it.
college,
And the pension is not here, na?
no, SG has,
Because it directly goes to the accountant.
Accountant General has done the pension part in the college research. Lordship.
The
So
respondent
SG and
number
the
1
respondent number
and
6.
1 and 2 shall apprise this court on the next returnable date as to why the amount of rupees 3,42,474 has been deducted from the total entitlement of the DCRG.
My Lord may also indicate respondent number 6 also, Lordship.
Who is sick?
6 is the college, Lordship.
1, 2, and 6.
Lordship.
11,
Apologies.
But primarily, Mr. Goa, you
Lordship, Lordship, I'll do. I'll do.
you
Lordship.
find out.
I'll do, Lord. I'll do.
Because I don't want to put a person who is not in notice because of the fact that
Lordship, I'll do. I'll do.
the
I'll do.
problem arises because here it is maybe it maybe just a case of wrong fixation of something to the
Lordship.
and as he was about to retire, it is within 1 year
Lordship.
he was supposed to.
I'll do. Lord.
That's fine. Yes, who appears for this? Yes, what is your case?
My lord, the matter pertains to my lord, non-payment of my leave encashment, employees provident fund, and my lord, deduction of pension from my area salary. My lord. What happened, my lord? I was earlier an employee of Guwahati University, my lord.
Hmm.
Pursuant to an advertisement, my lord, issued by the KK Hendrik State Open University,
Hmm.
I applied for the post of private secretary to the vice chancellor of that university, my lord. And accordingly, I was appointed as secretary in the year 2015, my lord, for a term of 5 years
Where?
at KK Hendrik State Open University. My lord.
Okay.
Thereafter, my lord, on 26/6/2020, my appointment order was extended up to my 65 years of age, my lord. But my lord, on 26/6/2020, that extension order was cancelled, my lord, by the Board of Management. Then I approached this honorable court, my lord, challenging that order, my lord. And lordship will find that order at page 39 and relevant portion is at page 51, my lord.
Page
51.
51.
51. Paragraph 27, my lord. May I read, my lord? In view of the above discussion, this court is of the unhesitant opinion that the impugn order dated 26/6/2020 is unsustainable in law. Accordingly, the same is set aside and quashed. Since the petitioner was forcefully debarred from rendering his services, it is directed that upon setting aside the impugn order dated 26/6/2020, the petitioner would be entitled to all consequential benefits for the extended period of service, which is up to 28/2/2022. This is the date of my retirement, my lord. Thereafter, my lord, they paid me arrear salary, my lord, from the date of my wrongful termination, my lord. But, my lord, they deducted the amount of pension, my lord, that I had received from the Guwahati University, my lord. But, my lord, as per pension rule, my lord, rule 21, it can be deducted only after the order passed by the governor, my lord. That too pursuant to a judicial or administrative inquiry, my lord. Nothing has been done, my lord. And, my lord, the university has taken the resolution, my lord, for payment of my employers provident fund, my lord.
So they
my
have
leave
deducted
encashment.
from the Guwahati University.
received pension from Guwahati University, my lord.
So from there they have deducted.
Deducted an amount of rupees near about 5 lakhs rupees, my lord.
So you have
And-
not made the Guwahati one University a party?
My lord, that is not disputed, my lord. I have received regular pension from
No,
them. my
from whom are you getting the pension?
I am, as on that, I am getting the pension from Guwahati University, my lord. That is, and when they paid me the arrear salary, my lord, they have deducted an amount of rupees 5 lakh from the pension amount, my lord. And my lord, they have taken resolution, my lord, and they have in fact issued order, my lord, for payment of leave encashment and employer's provident fund, my lord. That has not been paid till date, my lord. And my lord, as per the office memorandum of the finance department, my lord, I may be allowed to work for the month of March 2022, my lord, as my date of birth was 2nd of March, my lord.
So you have a whole lot of problems.
As on that, my lord. But my lord, they admitted that they will pay me, but till that, my lord, they have not paid this amount. My lord. So I'm before lordship. My lord.
Well, we'll have to issue notice.
My lord,
Heard Mr. R.M. Dekka, the learned counsel appearing on behalf of the petitioner. Issue notice, making it returnable on 24th of April.
my lord.
No, close. 24th of April खुला ना?
No, my lord, it's some holidays there, my lord, 24th and April.
Monday, but ठीक है.
Monday it is a holiday, right? This might have like
On 26th of April 2023. Steps upon the respondent numbers 1 to 4 by way of registered as well as usual.
obliged.
12.
May it please the Lordship, that in this case, the petitioner, who is a junior assistant LDA in the Department of Labor Welfare under the ESI scheme, challenging his suspension order, which was issued almost 2 years back, with until date, no charge sheet has been issued, my lord. Total contravention of the rules and the orders and judgments.
Suspension under what provision?
Under 6A, under 6 of the Assam Service Disciplinary Rules, my lord. Your lordship, in fact, Rule 6 clearly speaks the suspension can be issued only when it is under contemplation or when it is pending. Here, admittedly, till date, it has not been issued. What has happened, if I just take your lordship to 3 pages, first, if your lordship kindly come to page 66. 66.
Let us see a suspension order.
Well, I'll just take your lordship, just 1 minute. Page 66, this is issued on 15/10/2020. By this order, the petitioner was transferred to Khanapara, my lord. As your lordship seen,
Page 66.
page 66.
Okay.
And so after this, when we went to
And
Guwahati,
direction of the Minister of Finance.
transferred in the same capacity and
Yes,
posted
in
at
ESI
ESI scheme
What is
dispensary,
it? Yes,
Khanapara.
that
Now, when we proceeded to Guwahati, we were not allowed to join because from Jorhat, they were not releasing us.
Okay,
So
so you
we
have
were
been
filing
transferred from,
representation that please
you have been transferred from
Jorhat to Khanapara.
Jorhat to
To
Khanapara.
Khanapara. So when we
Then-
proceeded to Khanapara, when we went there, they said we get the release order.
Hmm.
However, the authorities in Jorhat was not giving that to us. In the meantime, we filed various representation. Then they stopped giving us salary. At that moment, we filed a writ petition, which is 2032 of 21 before this honorable court, where our categorical prayer was for release of salary from March 2020 and for allowing us to join in Guwahati. Now, when that case was pending, the government filed an affidavit in opposition. Shockingly, from the affidavit of opposition, we come to know that they modified this transfer order at page 66. And that order, your lordship will now find at page 72. Your lordship will kindly see this is an order dated 2010-2020, immediately after 5 days of the transfer order. The original transfer order at page 66. Then at page 72, your lordship will find 2010-2020. Here, the last line is hereby state at their original place of posting with immediate effect. This was never given to us, so we never knew. And interestingly, thereafter, if your lordship kindly come to page 74, this is the suspension order. This is way back of 24/12/2020.
pending drawing up of departmental proceedings, Mr. So-and-so Jorhat is hereby placed under suspension under Rule 6.1 of the Assam Service Disciplinary and Appeal Rules 1964 with immediate effect. This was never served on us. We didn't know.
The
So now-
suspension also.
Yes. So therefore, after coming to know about the suspension order and this, we withdrew that case. That order is at page 76. The operating portion, your lordship will find at page 77. We withdrew with liberty to file afresh. So, and then before we came, the last order, if your lordship can take at page 78. Now, people who were junior to me and also, and 2-3 people who were appointed along with me have been promoted. And I have been obviously left out because I am under suspension. Now, and accordingly, we've come before this court. My lord, your lordship may have the affidavit in opposition. Admittedly, no charge sheet has been filed till date. In absolute contravention of the law laid down in Ajay Kumar Chaudhary and various decisions of this honorable court. In fact, I find there is one of your lordships also, though that's a case of deemed suspension.
That's okay. Mr. Bora?
Your Lordship, let me seek instructions to notice go.
Well,
This is the affidavit, my lord, where from the suspension order has come to an order.
well. What are the prayers you are asking for?
My lord, that one, setting aside of the suspension.
You have
order,
already been suspended.
Yes, I'm under suspension.
As of now, there is no departmental proceedings
No,
initiated.
nothing has been done.
For the last 2 years also,
I'm hanging.
have you been paid the subsistence allowance?
That they have started paying after I filed the writ petition, that is in April. After the writ petition was filed, by an order, they have started paying 50%. Look,
Have you enclosed that?
yes, 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 it is there at page 75, 22,421. The writ petition was filed on this is after I filed the writ petition.
Lord Mr. K. Goswami, the learned counsel, senior counsel, assisted by A. Sandilya, learned counsel for the petitioner. Mr. D. Bora, you appear for
All the respondents given.
all. When can we get the instruction?
Your Lordship, 3 weeks time maybe.
What?
3 weeks. To prepare the affidavit, if need arises.
I'm saying 20. To get
20th
the
of March.
instruction as to whether the memorandum of charge has been given or not.
Well,
Not on that. 3
Your
weeks,
Lordship,
And on that, of course, that
issue
affidavit
notice
is already there.
making it returnable on 23/2023.
extra copy.
Yeah, we'll give it to them.
Extra copies of the writ petition be served upon Mr. D. Bora, the learned counsel, during the course of the day.
Can it be on 22nd, Your Lordship?
No? 20. Why?
If,
You are
because-
only to find out only one thing. Memorandum of charge has been given or not. Nothing more than that. The case of the petitioner herein is that the petitioner, by on the basis of an order dated 15/10/2020 issued by the Administrative Medical Officer, ESI scheme Assam, was transferred from the ESI scheme dispensary Jorhat to the ESI scheme dispensary Khanapara. By the said order, another person, namely Sri Rishikesh Gautam Pukar, was transferred to the post of the petitioner. Subsequent thereto, it is the case of the petitioner that on 20/10/2020, The said order dated 15/10/2020 was stayed by the same official, that is the Administrative Medical Officer, ESI scheme Assam. Full stop. However, this aspect of the matter was not brought to the attention of the petitioner. By another order dated 24/12/2020, the Administrative Medical Officer had suspended the petitioner under Rule 6 small I of the Assam Services Discipline and Appeal Rules 1964, pending broil of departmental proceedings. And after 5 months thereafter, this suspension order was also not brought to the attention of the petitioner then. It is only when the petitioner started getting the subsistence allowance on the basis of the order dated 22/4/2021 that the petitioner could come to learn that he had been suspended on the basis of the order dated 24/12/2020. The case of the petitioner herein is that the Supreme Court had, in the case of Ajay Kumar, what is that, Union of India or Ajay Kumar Chaudhary versus Union of India?
Ajay Kumar Chaudhary versus Union of India.
Reported in 2005, 7,
2015, volume 7 SSC at page 291.
and more particularly at paragraph number 21, had categorically mandated that the period, the currency of a suspension order cannot be more than, for a period more than 3 months. If within that said period, the memorandum of charge oblique the charge sheet has not been served upon the petition. It is therefore the case of the petitioner that the continuation of the suspension of the petition beyond the period of 3 months from 24 to, what is that?
15/10/20.
Huh?
Sorry, suspension date is
From 24 to
24/12/20.
24,
24/12/20, page 74,
24/12,
2020.
24/12/2020 is in violation to the law laid down by the Supreme Court. And consequently, the petitioner is therefore entitled to be reinstated forthwith. The learned counsel appearing on behalf of the respondent is directed to apprise the court on the next date as to whether the memorandum of charge oblique the charge sheet has been served upon the petitioner in pursuant in respect to the contemplated departmental proceedings.
Deeply obliged.
You take the step today.
Yes.
Item number 13, order stay vacating.
Your Lordship, the engaged counsel for the respondent number 1 private respondent is not present today, Your Lordship. Case in Itanagar bench, Your Lordship.
Huh?
The engaged advocate for the respondent number 1 is not present today, Your Lordship. In the given IA.
Who are you?
I'm Mr. A. Iqbal on behalf of the respondent number 1.
You are the second wife.
No, Your Lordship, I'm appearing for the engaged advocate. I'm on behalf of the respondent advocate number 1, Your Lordship.
Number?
Respondent number 1 advocate.
Who has filed the IA?
Your Lordship.
We have filed the IA.
You are the second wife or the
Yes,
first
Lord.
wife?
The second wife. Lord.
You are the second wife.
Second wife.
He's the first wife.
Yes, Lord.
Now what is the case?
case is Lordship, they have.
There is a direction not to pay
Yes, Lord.
because you are not entitled to.
Yes, Lordship. As per the pleadings, Lordship, they have stated in the writ petition, mainly Lordship, paragraph number 7 and 8. They have said that Lordship, I being the second wife is not entitled for.
You are the
personal
first wife or the second wife?
I'm the second wife, Lordship.
Very well. You are not entitled to.
Now, Lordship, as per the recent judgment of this Honorable Apex Court, Lordship, this Honorable Court, Lordship, I being the second wife, Lordship, is entitled for family pension.
Where?
Lordship, may kindly take up my IA, Lordship.
Which judgment?
Judgment, Lordship, judgment dated 22/12/2022. Passed in writ appeal number
You are
160.
reading paragraph 23.
Lordship, 23 is for direction as to whether the
Paragraph 22.
22, Lordship.
Yes.
No, Lordship, I am not reading paragraph 22, Lordship.
Which paragraph you are reading?
Lordship, I am reading paragraph number 15 and 16.
Huh?
Lordship. 15 and 16. Lordship.
Let us read it. 15 and 16. Tell
Page
me.
number 25, Lordship.
Ah.
As a reading of Rule 143(1) goes to show that for the purpose of family pension, a family would comprise of the relatives of officer, which also includes the wife in case of male officer. If the second wife or further wife of a male officer are acceptable and valid under the personal law governing the parties, we see no reason as to why such second or further wife would not be constituted to be a wife of a male officer. If the validity and acceptability of the marriage of a second wife or further wife, where parties are governed by Mohammedan law, would be determined by personal laws of the parties, and the personal laws provide for the validity and acceptability of such marriage, the second wife or further wife, where parties are governed by Mohammedan law, would have to be constituted to be also the family members of the deceased employee, and therefore, under Rule 143(1) of the Pension Rules 1969, be entitled to the benefit of family pension.
What you are entitled to?
Family pension.
Benefit. You are not entitled to the family pension. You are entitled to the benefit of the family pension.
Yes.
Yes. Now come to paragraph number
23.
20 onwards. Yes, read it. Paragraph 20.
Yes, sir. As a corollary to the provision of the Rule 143, Sub-Rule 143(3) of the Pension Rules of 1969, Note 1 to Rules 143(2) would have to be read to mean that family pension would be payable to the eldest of surviving widows in the event there are more or two widows, and thereafter on her death it would be payable to the next surviving widow, if any thereafter, to the minor children if the occasion arises. In the circumstances, the concept of validity and acceptability of a
So under such circumstances,
Yes.
you cannot get the family pension. What is your right? Let's read paragraph number 22.
We further hold that family pension being payable to the eldest of the surviving widow or wife would mean that the entire family pension so payable would be personal property.
Would
of
not
the-
mean. Would not
Payable.
mean. Ah,
would so payable to personal property of the eldest of surviving widow or wife of the family pension so payable would be held by the eldest of the surviving wife, widow or wife as a trustee for all such other persons who are entitled to the benefits of family pension in terms of Rule 143,
So she will be the trustee
first wife,
first.
first wife.
So as per this, it will, the family pension only has to be paid to him.
May I read the paragraph number 23 also?
Very well. Read.
We also provide that in the event of any such other person who are entitled to benefits of family pension in terms of Rule 143 of Pension Rules 1969, including the second or further wife, in a case where the parties are governed by Mohammedan law, are not appropriately maintained by the eldest of surviving widow or wife to whom the pension would be paid, the remedy thereof would be to make a claim for maintenance in appropriate forum under the law, and not a claim for a payment of family pension by the state authorities directly to such person. But
So your claim, you should file this type of IA in the civil court.
Lordship, may I read the last portion also? Lord?
Yeah.
But however, if in a given case, the state authorities on their own volition are of the view that under an acceptable circumstances, the authorities are agreeable or required to pay the pension separately to such member of a family of deceased employee, this judgment may not constitute to be an absolute bar on such separate.
Absolutely. So it is dependent upon the government. Go
Yes,
to the
Lord.
government.
Yes, Lordship, but because of
But
the,
you have no right otherwise to get the family pension. Matter ends.
may I submit, Lordship?
Yes.
Here, Lordship, the writ petition has been filed by the first wife.
Obviously, because you have been given the second. Have you been given the
No,
family
Lord, no,
pension?
no, Lordship. Nobody is getting the family pension. Nobody is getting the family pension.
Then why you have? If nobody is getting, then why you have to file the IA?
As because, Lordship, because of the stay order passed in writ petition, Lordship, nobody is getting the family pension.
So you want the family pension?
Yes, Lordship. Even Lordship,
No,
if
you
ask-
you don't have a claim to get the family pension. You have a claim. Go and file it in the civil suit.
but Lordship, because of the writ petition, Lordship, the family pension even is not being paid to the first wife
Okay.
also.
We'll
Lordship.
direct the family pension be given to the first wife, and
Lordship,
she will be act as a trustee, and we
Lordship.
claim it against them. And you shall also, we can direct the authorities to also take care of what you call
Paragraph
the
23.
order, the penultimate, the last portion of the order,
Yes, Lord.
and both the parties may request, and otherwise it has to be paid to the first wife. And the government may do if their discretion or volition and all these things are there.
Yes, Lordship. Yes, Lordship. Even Lordship, in paragraph number 11, Lordship.
Otherwise, he is entitled.
Otherwise, Lordship, if Lordship, may I read the paragraph number 11, Lordship, of that order, Lordship? Two issues were framed, Lordship. First, Lordship, as to whether the second wife is entitled for family benefit of family.
Mr. Counsel, I have read this judgment
Yes, sir.
100 times, and I have been thinking how to give a relief to the second wife. Not only here, about also the mother of in Hindu, what will happen to the mother also. I've been thinking, but I have not been able because of the school bench judge, with due respect.
Yes, sir.
So the best order is let the family pension go to them. And I give you the permission out there, liberty to approach the authority to act so that you being the second wife is also entitled to being a family entitled to the benefit. The authority may take a call on that.
Yes, sir.
That is the best way out.
Yes, sir. Even that will. By taking.
That is the best way out. On some other date, after this is until March. Once April comes, I'm just thinking of what is to be done. We'll have to ask the government to have some position unless they go for a review of this school pay. Because it is going to, every day I'm getting a lot of matters of. They are saying, where is the forum? The only forum as per this court is the civil court. And if I ask you to go to the civil court,
That would be.
you may die
Yes, sir.
before getting the relief. What do you say? You may not know the fact otherwise, but isn't this a practical difficult? Hello, I'm coming up at 5 minutes to pass on.
আপনি কই আসছেন? হ্যাঁ?
Heard Mr. So the learned counsel appearing on behalf of the petitioner. Give your name out there, huh? The irrigation, who is appearing? Here. So appearing on behalf of the respondent number 1 and 145. The 1, 3, 4, and 5. It's the T.S. Authority appearing on behalf of the respondent number 4. The SK Mehdi appearing on behalf of the respondent number 2. And Mr.
M. Ahmed.
M. Ahmed appearing for the respondent number 7. The case of the petitioner hearing that she is the first wife of one Abdul Haq, bracket since deceased. Late Abdul Haq was a grade 4 employee in the office of the Assistant Executive Engineer, Hatsing Mari, Mechanical Subdivision Irrigation, Hatsing Mari, in the district of South Salmara, Mankasar, Assam. After rendering more than 28 years of service, the husband of the petitioner expired on 26/9/2022. Admittedly, the husband of the petitioner had married the respondent number 7 in the year 2000. It is the case of the petitioner that that the respondents have taken steps for releasing the family pension and other pensionary benefits to the family pension to the respondent number 7, for which the instant writ petition was filed, challenging the action of the said respondents and for a direction to the respondents to pay the service benefits and family pension of the deceased government servant to the petitioner. This court, by an order dated 30/11/2022, had issued notice and in the interim directed the respondents not to disburse the retired benefits of the deceased employee till the returnable date. Being affected by the order dated 30/11/2022, the respondent number 7 has filed an interlocutory application seeking vacation, modification, or alteration of the order dated 30/11/2022 on the ground that the second wife, on the ground that the respondent number 7 being the second wife, is also entitled to the retirement benefits of the deceased government employee late Abdul Haq, as well as also for the benefits of the family pension. Two aspects arises for consideration. First is as regards the retirement benefits of late Abdul Haq, and the second is the family pension. Mr. Hazarika, what do you say about the retirement benefits? Retirement benefits both will be entitled to. It is in view of 143(3). Family pension is to be, but as regard to retirement benefits being of the Mohammedan family, they are entitled to equal. Yes, Mr. Borua, you want to say something?
Children of the second wife is entitled for the pensionary benefit. Children of the second wife, Mohammedan, they are entitled for the pensionary benefits.
That is why.
Yes.
The second wife otherwise is entitled to the retirement benefits. May not be the family pension, but otherwise the retirement benefits they have, because it becomes retirement benefits is the property of late Abdul Haq.
That is correct.
Let this court therefore take into consideration the first question as to whether the petitioner as well as the respondent number 7 are jointly entitled to the retirement benefits of late Abdul Haq. Admittedly, both the petitioner, admittedly, both the petitioner and the respondent number 7 and late Abdul Haq are governed by the Mohammedan law. The retirement benefits of late Abdul Haq such as the area pension and other pensionary benefits was a property of late Abdul Haq, which he would have been otherwise entitled to if he would have been alive. The respondent petitioner as well as the respondent number 7 as well as their children, in the opinion of this court, are therefore entitled to equal to the area pension bracket, if any, as well as other pensionary benefits in terms with the applicable Mohammedan law. You are Sunni.
Yes, Doctor.
Applicable Mohammedan law of inheritance. It is admitted at the bar that the law of inheritance applicable to the petitioner as well as the respondent number 7 would be the Hanafi law of inheritance. Consequently, this court therefore directs the respondent authority to release the area pension bracket, if any, as well as other pensionary benefits, which late Abdul Haq would have been otherwise entitled to if he had been alive, in equal proportions to the petitioner as well as the respondent number 7. The next question therefore arises is to whether the petitioner or the respondent number 7 would be entitled to the family pension in a recent judgment by the full bench of this court. In the case of MUSTT Junufa Bibi versus MUSTT Padma Begum, reported in 2022 SCC Online, GAU 2000. The full bench held that in terms with Rule 143 Roman 3 of the Assam Service bracket pension rules 1969, hereinafter for short referred to as the rules of 1969, and the note appended to note 1 to rule 143 Roman 2 the eldest of the surviving widow would be entitled to the family pension. It is upon the death of the eldest of the surviving widow, the next surviving widow, if any, and thereafter to the minor children, if the occasion so arises, would be entitled to the family pension. The full bench further made it clear that the entire family pension so payable to the eldest of the surviving widow would not be her personal property, and the eldest of the surviving widow or the wife of the surviving widow will receive the family pension as a trustee for all such other persons who are entitled to the benefits of the family pension in terms with Rule 143 of the Rules of 1999. In the penultimate paragraph of the said judgment, the full bench further mentioned that in case the second or the further wives, in the case where the parties are governed by the Mohammedan law are not appropriately maintained by the eldest of the surviving widow, to whom the pension would be paid. The remedy thereof would be to make a claim for maintenance in the appropriate forum under law, and not a claim for payment of family pension by the state authorities directly to such persons. However, the full bench also observed that if in a given case, the state authorities on their own volition are of the view that under an acceptable circumstances, the authorities are agreeable or required to pay the pension separately to any such member of the family of the deceased employee, the judgment of the full bench shall not be construed to be an absolute bar on such to make separate payments. Paragraph number 19 to 23 of the said judgment being relevant is reproduced hereunder. Taking into account the said judgment of the full bench, the petitioner, who is admittedly the eldest of the surviving widow, would therefore be entitled to the family pension. It is further observed that the family pension so received by the petitioner would be received as a trustee for all such persons who are entitled to the benefits of the family pension in terms with Rule 143 of the Rules of 1969. It is also the opinion of this court that if the respondent number 7 is aggrieved by not being maintained by the petitioner upon receipt of the family pension, the respondent number 7 would be at liberty to initiate appropriate proceedings claiming maintenance in the appropriate forum under law. Further to that, it is also observed by this court that if the petitioner and the respondent number 7 reaches any acceptable mode of settlement, the state authorities would be at liberty to pay the pensions separately to the petitioner and the respondent number 7. In view of the above, the instant petition therefore stands disposed of with the following observations and directions. Number 1, the respondent authorities are directed to release the area pension, if any, as well as the other pensionary benefits to which late Abdul Haq would have been entitled had he been alive. To the petitioner and the respondent number 7 in equal proportions. Number 2, the family pension be paid to the petitioner. By the respondents, respondent authorities. How much time? What? 2 months, 3 months? To the respondent, paid by the respondent authority to the petitioner. And the respondent number 7 shall have a claim over the said family pension if the respondent number 7 have not been adequately maintained. And in that regard, the respondent number 7 would be at liberty to approach the appropriate forum if to agree. Number 3. If the petitioner and the respondent number 7 enters into an acceptable mode of settlement, it shall not be a bar to the state respondent to pay the family pension to the petitioner and the respondent number 7 separately. Next. The entire exercise be carried out by the respondent authorities within 3 months from the date a certified copy of the incident order is served upon the respondent. Number
7.
No. Respondent number 2. Who is going to pay? Department, which one? That to the commissioner and secretary? Irrigation? To whom?
Chief, respondent number 3.
Respondent 3.
Respondent number 3 is given chief
To the respondent number 3. As well as no, to the respondent number 2 and 3. Huh? To the respondent number 2, to the commissioner and secretary, irrigation department, Assam, Guwahati 7, irrigation department, commissioner and secretary to the department, irrigation department, government of Assam. It is, however, relevant to take note of. Before concluding, this court would make it clear that this court had passed the instant order on the basis, without taking into account, without deciding as to whether, should I put it? Whether he was, because I don't know as to whether they are actually entitled to pension or not. They are entitled to.
AG will have to examine the department.
No, because this direction, without that option being given, if they are not entitled to pension,
They are not at all entitled to pension.
then
So that also-
before concluding, this court would observe that the decision rendered herein is না এটা কাম করো number 1 of video first number 1 1 to 3 not 1 the commissioner and secretary to the government of Assam irrigation department shall upon receipt of the certified copy of the instant order decide as to whether late Abdul Haq was entitled to pension as well as family pension, and his family was entitled to family. In the case, if it is found that late Abdul Haq is entitled to pension from a pensionary benefits as well as the family pension, the responding authorities are therefore directed to also take it out 1 to small 1 to. I think then it is better because this is without a direction because they may come up in even high sense disposed in
Highly applied.
3 months, huh?
Only they have sent all papers not the
Mr. Medhi, there is a glass. I'm thinking of removing it. Otherwise, come to the mic.
And the only thing, the office of the irrigation department, they will send all papers to the office of the accountant. Then, thereafter, that some time may fix. They will send on within 1 month or 2 months. Then accordingly, because
Okay, I'll make it 2 months for irrigation. And thereafter you take 1 month.
2 months.
Irrigation will send the papers after whatever is necessary to you within 2 months and 1 month
Yes,
for you.
yes.
I'll make that correct.
Yes.
2 months. I sense dispose.
Highly applied.
This will be in WPC. I sense disposed in view of it. You commission and take it and thereafter send papers to the office of the respondent number 3 to the respondent who shall within 1 month pass the appropriation. I will first direction to if in the case it is found that the respondent that Abdul Haq was not entitled to pension from a pensionary benefit as well as the family pension, the commissioner and secretary to the government of the irrigation department shall pass a reason order as regards why the same is not within the
14 and 15.
yes. David Keating.
No. In this matter, my lord, I need some time whether they are accommodated or not. They are, my lord, a Shipsagar irregular teacher, my lord.
No, Lordship. Lordship will kindly see the order of this honorable court dated 12/3/2021. Lordship.
In which case?
Please, WPC Lordship 6435. They are taking time and again, Lordship. 12/3/2021.
12/3/2021.
Lordship. At a motion stage, this court has directed to pay the current salary. And after that, was it 12/3/2021.
Alien part to file the affidavit of the fact Yes, what is your case? Non-payment of salary.
Lordship, petitioner was originally appointed OBB teacher. Hereafter, Lordship, petitioner has completed basic training. After completion of basic training, they were given the regular scale. Up to 2016, they were paid regular scale of pay. After that, Lordship, petitioner's names were included with the excess teacher of
You were
Rajasthan
initially OBB.
OBB,
Then
basic training.
706. Which one? OBB, which one?
OBB, Lordship,
4040 or 706?
404.
404. Okay. Of this 4040, something like 2000 has been retained. Now you come within the ambit of. So you have been there. Now then you completed a basic training. And after that,
we are given regular scale of pay.
then
Then we are paid up to 2016.
thereafter,
Hereafter, some of the persons were paid regularly. Some of the persons of the list were paid regularly. Hereafter, look, they have included our name with the excess teacher of Nazira subdivision, which were appointed illegally. That hereafter, our salary has been stopped. Inquiry has been completed. They have conducted inquiry. Inquiry has been completed. We are found regular, and thereafter, Lordship, they are not paying salary. That is why at the initial stage, Lordship is directed to pay our pay, initial regular scale, regular pay, current salary. And they are taking time from time and again. We have to survive those.
My lord, out of 14, three are already accommodated, my lord, as per my last instruction, my lord. So rest, my lord, I pray 1 week time, my lord, so that I will apprise before your lordship that whether they are accommodated or not.
accommodated under what?
Under tutor or teacher, my lord. If they are completed.
You are saying
basic-
about the 2020.
Madam.
He is referring to the 2020 thing.
Madam.
That office, that decision of the government.
Government, my lord.
That in
Training committee.
2021 time, illegal and irregular, everybody have been in.
My lord.
You are saying about that. Now, three of them has been accommodated against that order,
Yes, madam. As per my telephone.
841.
As per my telephone, I am not received the written, my lord. As per my telephonic instruction, my lord, 3 of them are already accommodated as and they are received salary, my lord. So I pray kindly allow me 1 week time, my lord, so that I can. And the entire file is lying in the secretary level, my lord. So I have unable to.
But what do you say about this matter has been pending from 2017, 18,
My lord,
and he has not got a single penny?
so my lord, I pay only 1 week time, my lord. Next week, my lord, on
The
Monday
same
also-
thing happened on 27/2/2023. Okay, I give you 1 week's time. Today is 15th, 22nd,
on 23rd, my lord, 22nd.
23rd. Why?
My lord, I
Is
will
this
out,
such a special matter to
No.
be on a 23rd?
no, 22nd, I will be out of this
Very well, get hold of somebody. In which department is this?
elementary duty.
So elementary, there are hundreds of counts. Let Mr. Khatonia take it. He is there. You get the instruction, Mr. Khatonia. This matter can't go on like this. Either this needs to be, something has to be there. They are working, you are working. Heard Mr. S.K. Goswami, the learned counsel, appearing on behalf of the petition. And Mr. N.J. Khatonia appears on behalf of the Elementary Education Department. The case of the petitioner herein is that they were initially appointed again as under the OPB scheme. Thereupon, their services were regularized.
After completion of basic training. After completion of basic training.
After completion of basic training, you got regular pay
Regular.
scale. So OBB, there has to be some regularization. The services were regularized to the services of the government. And they have also completed the basic, junior basic training in the year
2000, Lordship, 2001.
2001, you completed
Basic.
junior. 2001.
Most of the time. There are
And thereupon were paid the regular scale of pay. petitioner received their salary till the year 2016. However, thereupon, the petitioner have not been granted the salary on the pretext and have not been granted, have not been paid the salary for which they repeated, both the petitions have been filed. No affidavits. It appears that the instant matters have been pending, both the matters have been pending since 2017 and 18 respectively. And till now, till date, the respondent in the elementary education department have not filed any affidavit. Mr. N.J. Khatania, the learned counsel appearing on behalf of the elementary education department, apprises the court, submits before this 6 an accommodation of 7 days, so that he may bring the instructions in this matter and or file affidavit. Taking into account the state and also that the matter that the petitioners have been deprived of their salary since the year 2016. This court fixes the matter on 22nd of March 2023. It is made clear if no instructions are obtained as to why the petitioners have not been paid their salary till date, this court would be constrained to cause the personal attendance appearance of whom? Whom do you want? That he should apprise the court if you are not doing. Director of Elementary Education on such date as may be fixed on the next date. A copy of the instant order be given to Mr. N.J. Khatania for due compliance.
Wait, please, Lordship.
Yes.
Lordship, in this matter, I'm appealing for the respondent, Secretariat Administration. Here, my lord, the petitioner has not given us any copy, Lord.
My lord, earlier this matter has been represented by the GA of GA Assam. My lord. Earlier this matter has been represented by the GA Assam. So I think from 2022, my lord, they are representing.
2020.
What do you want? Granting of DCRG, GPF, GIS, saving funds, GIS, insurance, leave encashment has not been paid to you.
Yes, I am, my lord, I am claiming that I am a first wife, my lord. The respondent number 6 is second wife. And they have issued a letter to the second wife, my lord, for payment.
What is this second wife business?
Lordship.
Huh?
There was a second wife, Lordship.
Second wife of Hindu?
Objecting, Lordship, because second wife is not entered.
Huh?
That is clear.
What do you want now?
No, my lord, direction will be given to the authority, my lord, to release the, my lord, pensionary as well as child benefit.
To grant the retirement pensionary benefit, including so and so of the deceased husband, as well as the monthly family pension. Now, what do you want?
Lord,
You don't have a copy?
I don't have a copy, my lord. I'm not aware. I'm clueless. My lord, 1 week time at least, or I need, I need some time. Get my instructions from the department.
Heard, Mr.
K. Sinha, my lord.
K.
K. Sinha.
A. Sinha, the learned counsel appearing on behalf of the petitioner. Mr. A.
Hukan,
Hukan appears for
Secretariat Administration Department. 1 to 4 men.
appears for respond number 1 to 4. Who appears for 5?
I'm for 5. One submission if I may make your
Mr. C. S. Hazarika appears on behalf of respond number 5. Yes, what
Here
do
I
you
think your lordship, AG will be required, Accountant General will be required. I see in this case that AG has not been made a party. It's a matter of pension. So
appears for respond number 5? And Mr. M. Bhagavati appears for the respondent number 6. Yes, Mr. Talukdar. Don't go, wait. Mr. T.S. Hazarika, the learned counsel appearing for the respondent number 5, say, submit. In the instant case, as in the instant case, the petitioner's claim is for pension and the other pensionary benefits. Without the office of the accountant general being made a party, the instant petition would be not maintainable. Taking into account that the matter pertains to pension as well as pensionary benefits, this court, for the ends of justice, is of the opinion that ends of justice would be met if the office of the accountant general is made a party, is implemented as the respondent number 7 to the instant proceedings. Accordingly, the office of the principal account, or the office of the principal, what is that?
Principal accountant, A&E.
Principal accountant general, A&E, Assam, having their office at Moidamgaon, Beltola, is arrayed as the respondent number 7 to the instant proceedings. The registry shall make necessary correction of the records according. The learned counsel for the petition is directed to that Mr. R.K. Talukdar was present in the court, accepts notice on behalf of the newly implemented respondent number 7. The learned counsel for the petitioner is directed to serve extra copies of the writ petition to Mr. R.K. Talukdar during the course of the day. Mr. A. Pukan, the learned counsel appearing on behalf of the respondent number 1 to 4, had also submitted that he requires extra copies of the petition. So, taking into account the same, the petitioner is directed to serve extra copies of the writ petition during the course of the day. Let the matter be listed on 29th of March 2023.
Bless.
18,
Yes,
Matter government affidavit is necessary as today is the first time after return.
so comment, what is the matter about?
Matter is
Apart for the reinstatement.
petitioner was initially appointed as grade 4 employee. Lordship, and
Washing
he-
the order. What order? What order you are challenging?
No, Lordship, this is the kindly see the first court order, Lordship.
No. What order you are challenging? Setting aside and quashing the impugned letter dated 10/8 and impugned letter dated 2/2. And where's
Yes,
the
sir.
hell?
Page number 37, Lordship.
Page number 37. And they have not cared to reply to you.
No, Lord.
That-
And the page number
My
41 is
Mr.
another
Ray,
order, Lordship.
hereby reinstated and allowed to report his. Who are you?
Lordship. I am the
City
grade 4.
Ahmed. Why you agree? Mr. Ray is hereby reinstated and allowed to report his joining service at 12. Why are you challenging this order?
After the fact, Lordship, after the court order, Lordship, I have been reinstated, Lordship. In the meantime, I was elected as member of Legislative Assembly, Lordship, MLA, Lordship.
You
Yes,
became?
here, MLA, Lordship.
Wait. Now why you are fighting litigation?
No, Lordship, because of after the court order, Lordship, this is the admitted fact, Lordship. I will get the benefit of pensionary benefit and also the arrear salary, Lordship. All these things are calculated also, Lordship. Kindly see the court order, Lordship. Just one.
Now what happened? Why you are before this court?
Because of arrear salary and other benefit also.
MLA asking for area salary?
Kindly see page number
Which
30.
party were you
Kindly see
in?
this order, Lordship.
Which party?
Congress.
Recently?
Recently also MLA. Kritika. At that time he was minister.
Hmm?
Minister of Industry and Commerce.
You are minister also?
Yes.
Minister asking for area salary.
So kindly see the court order, Lordship, page number 34.
Yes, no health department.
Call- call- someone is
But in this matter,
I'll call
everything is necessary. Important.
Yes, madam. Why haven't you filed your
Lordship, in
affidavit?
this case, Lordship, due Bomani is appeared, Lordship, he is on lakes. So Lordship may kindly take it up at 2 o'clock, Lordship.
2 o'clock, this court has no time, but why haven't you filed affidavit?
It is,
Here, the notice was issued on 16/9/2020.
actually, I am not aware of this case. Lord. Just he has informed me to pick up the matter at 2 o'clock.
Okay, we'll take it up at 2. Direct them to do something.
Obliged with me.
Nineteen to 34.
My lord, may kindly have this item 23 that I have been given that. Same issue.
You have filed your affidavit?
No, my lord, not yet.
No.
Why?
Though there was a direction, my lord,
Mr. B. Kaushik, the learner, appears on behalf of the secretary and submits that taking into account in the batch, the issue remains the same. The government will file a comprehensive affidavit where issues involved in all the area would be taken care of. He submits that affidavit will be filed on or before 24th of February.
I've seen the order, my lord.
You don't want to file affidavit,
No, my lord, we want to file affidavit.
then
but
why it
I
has
would-
not been filed? We are in the month of,
Yes, that I understand, my
Must.
lord.
Then?
Otherwise, I have no other explanation also, my lord, to that
Then?
regard, because this is our lapse on our part, my lord. That's why we
Then?
could not file.
made clear that taking into and that in spite of the orders having been, the petitioner has not been paid the salary, the respondent in the secondary net shall file their affidavit without fail on or before the next date indicated. Then
That is lapse on our part, my lord.
who was to file the affidavit?
Secondary Revision Department.
Secondary who one? Whom do you propose to file? To
Normally,
be
my
the
lord,
deponent.
normally, my lord, director,
Direct.
and sometimes secretary also, my lord.
So
Once-
we impose the cost on him, from his salary.
Because
1 lakh.
this is not their part. This is not their fault, my lord. This is our fault, my lord, because,
Your fault.
yes, my lord, we are,
So we impose the cost on you,
yes, my lord.
1 lakh. You paid the you. But Mr. You want to file the affidavit?
Yes, my lord. But not 1 lakh cost, my lord.
1 lakh. Because there is a direction.
Yes, I understand, my lord. I'm not
See,
disputing that, my lord.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16. 16 matters. You are supposed to file 16 affidavits. We have made it into one. So just 5,000 or 6,000. You want, I can pass in each case separate orders of
In fact, my
7,500
lord
each.
was pleased to allow us to file a comprehensive affidavit, but due to some
What's up?
gap on our part, my lord, we could not file in due time. That I admit, my lord, there is a lapse on our part, my lord.
You filed the affidavit on 20/20. I'm giving you time till 20. And if you don't file, then the cost.
Yes, my lord. I'll
20.
file by 20, my lord.
We'll give them time till 20. And then no, otherwise cost the 1 lakh.
Yes, my
I'm
lord.
putting you to notice now.
Yes, my lord.
Heard Mr. P.K. Goswami, the learned senior counsel, assisted by Mr. B.P. Bora, the learned counsel for the petition. on 27/1/2023, when the matter was taken up, the Learned Standing Council, appearing on behalf of the Secondary Education Department, had categorically made a submission that they would be filing their affidavit without fail on 24/2/2023. This court, taking into account that the petitioners have not been paid their salary, have specifically directed the Secondary Education Department to file their affidavit without fail on or before 24/2/2023. Mr. N.J. Katania, the Learned Counsel, appearing on behalf of the Secondary Education Department, submits that on account that they have already received the instructions, but it was on account of the fault of the council that the affidavit could not be filed. This court grants the Secondary Education Department a further opportunity to file their affidavit by 22nd of March 2023. It is made clear that if no affidavit is filed on or before 22nd of March 2023, the respondent in the Secondary Education Department or Secondary Education would have to, would be imposed cost of rupees 1 lakh, taking into account that on the earlier occasion, there was a specific undertaking to file the affidavit on or before 24/2/2023. This court therefore puts the Learned Counsel for the Secondary Education Department on notice for filing the affidavit. Else the cost shall be imposed, which shall be recovered from the salary of the erring official. List the matter on 24/3/2023. Thereafter, we'll see. If they don't, then we'll take a call.
Praying for time for reply. Let them
Absolutely.
file,
We'll
we
see.
can-
If they don't file it,
we'll-
then we'll.
we'll see what
Obliged,
is there.
Lordship.
Thirty-eight and 39.
Yes, why your files are so thick?
Yes, my lord. My lord, matter relates to my lord risk and hardship allowances to the petitioner.
Huh?
Risk and hardship allowances to the petitioner.
What salary?
Risk and hardship allowances, my
Risk and
hardship
hardship
allowances.
allowance
The
to the
petitioner deployed under 20 battalion, my lord.
affidavit file,
Yes, my lord.
reply file.
Yes.
Then
Then my lord, petitioner initially, my lord, is my lord 163, my lord. My lord, approval order, my
what?
page 163, my
Who wants the amount? Everybody wants,
Yes,
or one petitioner wants?
everybody. Everybody.
How many petitioners are there?
Yes, my lord, here is my lord. 408, my lord,
Ah.
in 47/9.
So choose one of them in whose favor the order will be passed. Others, this court is not going to incline. You have not paid the court fee. In one case, it is 408 and the other case is
Yes, yes.
330 2.
Yes.
Then 700 persons. 700 into 50, 3,500? 35,000?
Yes.
Court fee, you have to pay.
I thought,
This has to be paid. How much time do you want?
I thought
Lord-
2 weeks. I thought.
Lordship, there are two matters, 38 and 39 item number. I am in 39 and Mr. B Chakravarti is supposed to do the matter for 38, item number 38. So he's not in the court at the moment. It may be for the time being.
I'm giving him how much time?
2 weeks.
2. I'll give him 3 weeks. I'll have this matter again on 26th of April. Pay your court fee. Heard, Mr.
M. Kolitam.
M.
M. Kolitam.
Kulta, the learned counsel appearing on behalf of the petitioner, and Mr.
Please forget.
So and so appearing on behalf of the respondents. The case of the petitioners in the two writ petitions are claimed for
Risk and hardship allowance.
risk and hardship allowance to each of them, which have been denied by the respondents.
Initially paid, my lord. Then initially paid, my lord. Then they are stopped, my lord.
Which were initially paid but have been subsequently stopped. The claim of each of the petitioners being distinct and separate this court is of the opinion that that the court fee for each of the petitioners have to be paid. In WBC number 4379/2021, although there are 409 petitioners, but a court fee for only one petitioner has been paid. In WPC number 4378/2021, although there are 332 petitioners, but the court fee of only one petitioner have been paid. The learned counsel for the petitioner submits and undertakes to pay the court fee, deficient court fee, within 4 weeks from today. List the matter again on 26th of April 2023. In the meantime, the learned counsel for the petitioner is given, shall make the payment of the court fee.
I'm appearing for all responsibility.
Huh?
I'm appearing for all responsibility.
She was appearing for all the.
There is a matter interim order, matter. There is an interim order.
The interim order so passed earlier shall continue till the next.
Right.
Forty-three.
Yes,
The matter pertains to.
you have made a request, so we fixed it today. What do you want?
Lordship, the respondent authorities ought to file an affidavit.
Why they are not filing affidavit?
No order has been passed as yet.
Huh?
No order has been passed as yet so far as filing of affidavit is concerned.
Why they should know it when notice is issued?
Exactly.
Taking into account the parties are represented, let the matter be listed for admission. Heard, notice issued in 2021. Yes, what do you have to say, Mr. Sharma? Mr. Roy?
PWD lordship, pension lordship.
Who is paying for accountant general? The PWD directly goes to accountant general. I hope you have made it. Yes, please say. release the family pension, leave encashment, so and so with due interest. Good.
That I filed an additional affidavit, Your Lordship.
For what?
Means I received a letter from the Accountant General asking me to furnish all the relevant documents, which
You
I
have
have
got
already
some
done.
money?
No, Your Lordship. I have
Hmm.
submitted all the relevant documents.
Ah.
Only thing is that they haven't taken my thumb impression. I was very much present in the office. They haven't carried out that particular formality.
We'll do one thing. We'll take up the matter too. Let's see whether the accountant general is there or not. But Mr. Roy, this is a case where when did your entitlement arose when? You are asking for family pension, means it was actually, did your husband get
Husband.
anything?
Yes, Your Lordship. I was regular in 2005, Your Lordship.
Your husband got anything or not?
No, Your Lordship. Nothing.
You were regularized in?
In 2005.
How?
Lordship was- It's 33 years.
Oh. Then how will you get all these things? Huh, Mr. Roy?
Lordship.
Wouldn't he come within the ambit of the new pension scheme?
No, Lordship, that he was regularized as per this created in 2005, Lordship.
So, 1 to 2005.
1 to 2005.
Leave encashment. Obviously, leave encashment, he will be entitled. Area pay, he will be entitled. GPF, he may not be entitled. Group insurance, gratuity. Gratuity, he'll be entitled to. Group insurance, he'll be entitled to. But family pension, whether he'll be entitled to?
No.
If it doesn't come under the rules, find it out. We'll take it up at 2.
Lordship.
And get hold of the accountant general.
Lordship.
This is an old instruction you are
Lordship, he was
placing.
working in Dimahasa at that time, Lordship. Dimahasa, Lordship.
So?
So our director has sought for the arrear statement, Lordship.
Hmm.
So the last, Lordship, 2015, that year, Lordship, that year, that some months, Lordship, there is a confusion regarding that period, Lordship. So they are examining the matter, Lordship.
Now, what is the confusion? Let me make it clear. What is the
Rest, Lordship,
confusion?
he has got everything. Pension, he has got his pension and everything, Lordship. The arrear salary, Lordship, we are examining the matter, Lordship. In the period of 3 months, it will be cleared, Lordship.
Hmm?
In a period of 3 months, Lordship.
Last time also 3 months we fixed it.
That is what, Lordship, they are examining the matter, Lordship.
You were examining then also, and you have the matter was taken up on 14/12. You
Lordship,
gave
yes.
these same instructions then also, and today also it's the same
This
instruction.
instruction, Lordship, I didn't.
Yes,
raise
this is
last time.
3/12.
The instructions are old, Lordship.
Then
Lordship,
you
he
are
was
not giving
released from
anything new.
service from Dimahasa on 15/12/2014, Lordship.
Hmm?
He was released from
Yes,
Dimahasa
this is
on
the same
15/12/2014,
document you are referring to.
15/12/2014, Lordship. He was released from Dimahasa.
Hmm.
And his arrear salary is till June 2015, Lordship. So the period from January 2015 to June 2015, Lordship.
No, no, it is from September 2012 to
Yes, Lordship,
31/7.
that time he was working in Dimahasa, Lordship. Till 2014, he was working in Dimahasa. And his arrear salary is till June 2015. So that 15, Lordship, some months, there is a confusion.
And when it is going to be resolved?
Lordship, in a period of 3 months, Lordship, he'll
The
get-
last time also we gave 3 months. Then is there any denial of the fact that he is not entitled to?
No, he's entitled.
Then why this court shouldn't direct you to pay
Yes, yes, Lordship,
within 3
Lordship may
months?
direct it.
Heard Mr. B. request to the learned counsel appearing on behalf of the petitioner. And Ms. G. Bora, the learned, G. Bora?
Arbora.
R. Bora, the learned
Agriculture
standing
Department.
counsel for the Agricultural Department of Government of Assam. On 14/12/2022, the learned counsel for the standing counsel for the Agricultural Department had submitted that the proposal for the petitioner's area salary has been received on 7/12/2022, and it would take around 3 months from that date to be processed. In view of the said submission, this court had fixed the matter today on 15/3/2023, on which day this court directed the learned standing counsel for the Agriculture Department to apprise this. The case of the petitioner, in brief, is that the petitioner is entitled to an amount of rupees 13,27,294. As area salary for the period from September 12 to 31/7/2015, while the petitioner was serving as the additional director of agriculture, Dima Hasao. The learned counsel for the petitioner, for the learned standing counsel for the agricultural departments admits that there is no denial to the fact that the petitioner is entitled to the amount for the area salary for the said period. And as such, a direction the petition can be disposed of with a direction to the respondent authority to make the payment within a period of 3 months from today. Taking into account the said submission made by the learned standing counsel for the agricultural department, this court therefore disposes of the petition with a direction to the respondent agricultural department to take appropriate steps in the matter. For disbursal of the area salary of the petitioner to which he is entitled to for the period from September 2012 to 31/7/2015. In the said process, while processing the petition, the respondent in the agricultural department shall also take appropriate steps for sending the proposal to the Accountant General Office so that the payment can be released.
Lordship, in this case, Accountant General no role to play in respect of area salary. Lordship.
So it will be directly
By the department. Lordship.
okay. Now it will line to say.
After taking approval from the finance department, they will send the file to the finance department.
In that regard, if necessary, the respondent in the agricultural department shall take appropriate steps for obtaining the necessary approval from the finance department of the government of Assam. The said exercise be carried out within a period of 3 months from the date. A certified copy of this order is served upon the Commissioner and Secretary to the Government of Assam, Agricultural Department. With the above observations and directions, the petition stands disposed.
Lordship, my presence may be shown, Lordship.
Yeah, yes, my lord, as per the
Huh?
yeah, yes.
You have not got the GIS. It is a further case. It is also the further case of the petitioner that the petitioner have not received the GIS amount. The respondent in the agricultural department, along with
No, Lordship, GIS also by
shall also take appropriate steps within the said period of 3 months for payment of the GIS amount to which the petitioner is entitled to within the said period of 3 months.
Lordship, I am for Aspen number 13, my name may be recorded.
R.K. Talukdar for Accountant General, T.S. Hazarika for the state.
18.
Lordship, here in this matter, I need 3 weeks time to file my affidavit, Lordship.
Why?
Lordship, this matter has been listed after 16/9/2020, Lordship. On 16/9/2020.
For this matter, you appeared,
Yes,
na? That,
yes,
huh? Okay, I remember. I fixed it. Yes. Why you have not paid?
Lordship, I do not have the instruction, Lordship. Let me have the.
Understood, but this have happened in 2020.
Yes,
We are in 2023.
Lordship, this matter was not even listed, Lordship. It was not listed, Lordship, the matter, Lordship. 3 weeks time, Lordship, I will take the instruction and.
No. 3 weeks it goes for a 6. I had heard Mr. Endor,
AU Ahmed.
A.U. Ahmed, the learned counsel for the petitioner. The instant petition has been filed by the petitioner seeking a writ for quashing of the letters dated 10/8/2011 and 2/2/2012, and for a further direction that the petitioner be paid the area salary and allowances, pension, gratuity, GPF, and other service benefits to the petitioner for the period the petitioner had rendered service under the Joint Director of Health Service, Leprosy. It appears from the record that on 16/9/2020, notice has been issued, and till date, the Health Department has not filed any affidavit. This court fixes this matter again on 26th of April 2023. The respondent in the Health Department is directed to file their affidavit within the said period. It is made clear that if no affidavit is filed on or before the next date, the instant writ petition shall be taken up for disposal on the basis of the available pleadings and the materials on record.
Lordship, can it be on 27?
Why?
Lordship, on 26, I have some difficult. 27, Lordship. 27, 28, Lordship, any day.
21st.
20?
31st of March.
Lordship, 20.
31st of March.
Lordship,
You
26.
won't have the difficulty. 31st of March. You file. You ask for 3 weeks.
Lordship, 26 is fine, Lordship.
31st of March. Yes. Finance.
Lordship, so far as the instruction relating to senior salary is concerned, Lordship, that is awaited, Lordship. And pension proposal has already been submitted to the AG, Lord.
Yes, what do you have to say? The Accountant General, Mr. R. Dhar was appearing, Rupak Dhar. Yes, what do you have to say?
Mr.
Huh?
Ardor was appearing, Lordship.
Understood?
Yes.
R. Dhar, R.K. Talukdar, or whoever it is appearing, all are appearing on behalf of the Accountant General of.
Lord.
You keep on changing.
No, Lordship.
Does it mean that the
Lordship,
case
I'll
will
obtain
change?
instruction, Lord. I'll obtain instruction.
When?
Next week, Lord.
And finance, what is this? Area salary, what is the status?
Lordship, that instruction is awaited. Lordship.
Why?
Your area salary, Lordship. We have already communicated. Lordship.
When can we get it?
Next week, Lord.
We fix it on 27th of March.
After 1 week.
27th of March.
Lordship, in this case, Lordship, prayer for area and pending salary, Lordship. In this case, Accountant General has no role, Lord.
Classification, Lordship, Accountant General was made party.
Yes.
There is a question of pension.
No, because earlier it was submitted that is further seen from the instruction that the pension papers, there's a question of pension, were again forwarded. He has not got the pension also.
Yes, Lordship.
Yes.
regular pension
So
was
that is
received.
why you come into the picture.
Lordship. But in the prayer portion, Lordship, only area and pending salary, Lordship. That is why, Lordship. Page 9, Lordship. There is no such prayer, Lordship.
No, but in paragraph number 10, it is mentioned.
Lordship.
He has not got his pension. You get your instruction. Pardon, Ms.
P. Taluk.
P. Talukdar, the learned counsel appearing on behalf of the petitioner. Mr. P. Nayak appears on behalf of the finance department. And Mr. R.K. Talukdar appears on behalf of the Accountant General AE. Both the counsels appearing on behalf of the respective departments have sought for an accommodation for a week so that they can obtain the instruction in terms with the order dated 17/2/2023. Taking into account the same, let this matter be listed on 27th of March 2023, on which date the learned counsel for the finance as well as the Accountant General AE shall obtain the necessary instructions in terms with the order dated 17/2/2023. Liberty is given to the petitioner to mention the matter for upgrading.
Obliged.
36 and 37.
35 very good. Yes, what is your case?
Instruction was for matter from finance department. Higher duty department. Salary of
What are you asking for? Petitioner's claim pending before the State Department. Where's the finance?
Lordship's finance. So here the now Lordship matter is pending before the Lordship Secretariat. We have not received a non-royal certificate from the Treasury Officer, Lordship.
From the?
From the Treasury Officer, Lordship, Kamrup.
What you have not received?
Non-royal certificate, Lordship.
So with that you can process.
Lordship, now Lordship, today just before coming to the Honorable Court, Lordship, I have talked with the Deputy Secretary of the Higher Education Department. She informed me that college principal will submit the non-royal certificate by obtaining the signature of the Treasury Officer, Lordship, within a period of today or tomorrow, Lordship. Then we can process it. Lordship may fix it after some days.
non-rural have been submitted, madam. I have
NOC is submitted by the petitioner, but non-royal certificate should be submitted by the Treasury Officer, Lordship.
That has been submitted, my.
When?
Just now, my lord. Just 10 minutes before. I have got the information from the.
To whom?
By the college, my lord.
To whom?
Department, my lord. Higher Education, Department of Higher Education, who issued the.
So we'll take it up after on 31st.
Lordship, Lordship.
Mr. K. Gogoi, the learned counsel appearing on behalf of the Higher Education Department has submitted that
Non-roll certificate.
that the respondent number 4, that is the principal of BRM Government Law College, as well as the treasury officer, which where
Kamrup Metro.
Kamrup Metro, have today submitted the non-royal service certificate. Consequently, he submits that he requires some time to obtain the necessary instructions pertaining to the petitioner's claim as to when the said amount would be paid or disbursed to the petitioner. Let the matter be listed again on 31st of March 2023, on which date the learned counsel for the Higher Education Department. You want also the direction? No.
Lordship, who
Shall obtain the necessary instructions in that regard. Okay. Liberty is given to the petitioner to mention the matter for appeal. What about the contempt?
contempt is arising from that.
The contempt will just let the matter be listed along with this.
Lordship, okay. Oblige, Lord. Oblige.
Lordship, we have received the non-roll certificate, Lordship. 3 weeks time, maybe your Lordship may dispose of within 3 weeks, we'll disburse the amount, Lordship.
For GPF,
GPF,
88,000.
88,000.
Okay. Heard Mr.
M. Ali.
Huh?
M. Ali.
M. Halid.
M. Ali.
M. Ali,
Yes.
the learned counsel for the petitioner. Mr. B. Chakraborty appears for the Accountant General AE.
135.
And Mr. You are appearing for something?
Elementary.
Mr. B. Talukde appears for the Elementary Education Department. And Mr. P. Nayak appears for the Finance Department. The instant writ petition has been filed by the petitioner, being agreed by the non-payment of the amount of rupees 88,000 to which the petitioner is entitled to. Now, which to the amount of which have been illegally withheld while disbursing the GPF amount to the petitioner. Mr. B. Chakraborty, the learned counsel appearing on behalf of the Accountant General AE, submits that
Lordship,
the non-royal certificate.
Lordship may not record illegally, Lordship, because of the non-roll certificate, non-receipt of the non-roll certificate, that's why it's not.
No. Easy. The case of has not been with. Mr. B. Chakraborty, the learned counsel appearing on behalf of the Accountant General AE, submits that on account of non-receipt of the non-royal certificate, the said authority could not release the amount of rupees 88,000. He submits that the said amount would be released within a period of 3 weeks from
Because as you have
from
received
today.
the non-roll certificate.
From today. As the non-royal certificate has been received today. Taking into account the said submissions, this court therefore disposes of the writ petition with a direction to the Accountant General AE to disburse the amount of rupees 88,000 within a period of 3 weeks from the date of the instant order, with the above the petition stands.
Lordship will submit a copy of this order.
Huh?
You will submit a copy of this order. Lordship.
Why do you want it? You have it, you are present, take a copy of.
Oblige.
A copy of the
41.
instant order being served upon Mr. B. Chakraborty by this court, by the registry for due compliance. Yes, what do you want?
My lord, on the last occasion, lordship directed.
Area salary from the months of January to August.
My lord, we'll pay the salary within 3 months.
3 months? Why? What is this property? Which department?
Industrial Cooperative
Industrial
Bank.
Cooperative Bank.
Yeah. So you are going to pay it
Yes, madam.
within 3 months
Yes, madam.
from today?
Yes, madam.
Heard Mr. H. Chakraborty, the learned counsel appearing on behalf of the petitioner.
S. Das, MS Das, correspondent 1 and 2.
S. Das
Yes.
appears on behalf of the respondent number 1 and 2.
We saw appearing on behalf of G. Bordley, Study Council Corporation Department. That's been trained
Mr.
for-
G. Bodley.
No, behalf of G. Bordley.
No, there is no behalf of either G. Bodley or you. Who?
He is solo, okay. He is solo, myself.
So and so appears on behalf of the respondent number 3 and 4. That is the corporation department of the government of Assam. The instant writ petition has been filed by the petitioner. Claiming the area salary for the period from January 2021 till
My lord, when this writ petition was filed, he was not getting salary, but after the interim order passed by this honorable court, he got his salary
from September.
from, yes, up to from September. So the area is from
So,
January to August.
Yeah, so claiming the salary from January to 2021 to August 2021. The learned counsel appearing on behalf of the respondent number 1 and 2 has submitted on instructions that the said respondents would disburse the amount of rupees or disburse the area salary of the petitioner to which he is entitled to within a period of 3 months from the date of the instant order. Taking into account the said undertaking given by the learned counsel appearing on behalf of the respondent number 1 and 2, the instant petition stands disposed, thereby directing the respondent numbers 1 and 2 to disburse to pay the area salary of the petitioner for the period from January 2021 to August 2021 within a period of 3 months from the date of the instant order.
Forty-two.
Yes, Mr. Sekya.
Pertains to non-payment of salary for 4 months, my lord. Or page 27, my lord, the district elementary education officer, my lord, he has wrote a letter to the director, my lord,
Yes.
for making the available fund.
Where is it? What is your instruction?
Proposal has been sent to government, my lord, for release of the amendment.
Then
Already even on 29 January 2020,
23.
29 January 23, my lord.
Then so entitlement is accepted.
My lord.
We direct to pay within 3 months.
Right.
Heard Mr. P.J. Saikya, the learned counsel appearing on behalf of the petitioner, and Mr. P. Talukar, the learned counsel appearing on behalf of the elementary education department.
For respondent number 2.
Mr. P. Nayak appears for the finance department. You have any say?
No.
The instant writ petition has been filed, being agreed by the inaction of the respondent authorities in not releasing the area salary of the petitioner for the period from 1/11/2012 to 28/2/2013. While the petitioner was serving as the assistant teacher in Tengabari LP School under Mongoldoy Block, Dorong. The Learned Council, appearing on behalf of the Elementary Education Department, had submitted that the entitlement of the petitioner is genuine. And therefore, the Director of Elementary Education have issued a communication on 29/1/2023 to the Secretary to the Government of Assam, Department of School Education, for according the necessary sanction for an amount of rupees 63,712 out of the budget provision provided under the head of account during the financial year 2022-23 for payment of the area salary to the petitioner. The said communication have been placed on record by the Learned Council, appearing on behalf of the Elementary Education Department during the course of the hearing, and the same is kept on record and marked with the letter X. Taking into account that the entitlement of the petitioner for the amount of rupees 63,712 being the area salary for the period from 1/11/2012 to 28/2/2013 is duly admitted by the respondent authorities. This court therefore directs the Secretary to the Government of Assam, Department of School Education, to accord the necessary sanction and thereupon to make the payment to the petitioner. The amount of rupees 63,712 within a period of 3 months, from the date a certified copy is served upon the Secretary to the Government of Assam, Department of School Education. With the above, the instant petition stands disposed.
Obliged.
43.
Yes, Dimahaso.
In this matter, the petitioner has already divorced, already been divorced, and she has remarried.
Oh.
I'm not aware of what is taking.
Huh?
Find out what the Learned Council was saying.
You are asking for family pension.
Yes, your Lord. Pension.
And are you asking for the composite? You are asking for compassionate family pension.
Yes, your Lord. Only the family, because I might not be entitled to the family pension since I died in the petitioner's husband died into a minor furnace. So I will be entitled to the family pension as well as the area pension, whatever I'm entitled to.
Are you entitled to family pension?
Since I had died in June, since the petitioner's husband died in furnace here, I guess.
When did you divorce? There was no divorce.
There was no-
You got remarried.
No, your Lord.
He says?
Yes, sir.
Let him come on, let that come on record and let him final affidavit, your Lord.
Oh, okay.
I will speak to my
Mr.
She Sharma, Lord.
C. Sharma, preparing for Dimahaso.
Yes, sir. 6 to 9.
The Learned Council, Mr. C. Sharma, appearing on behalf of the respondent number 6 to 9, submits that the petitioner is not entitled to the claim as made in the writ petition, taking into account that the petitioner, after the death of her husband, no,
Not after the death, Lord.
the petitioner during the lifetime of her husband had divorced,
Yes, Lord.
had divorced Mr. what is his name?
Monikanta Roy.
Late Monikanta Roy, and thereafter have remarried. Taking into account the said submission, this court deems it proper that the same needs to be put by way of an affidavit so that the petitioner is in a position to rebut to such allegations. Accordingly, let the matter be listed again on 21st of April 2023.
Can it be after vacation on 26th of April?
21st of April 2023, by which time the respondent number 6 to 9 shall file the affidavit. You file, thereafter we'll see. Once the affidavit, let them file the affidavit.
46,
Petitioner is not receiving his regular pension. He retired on 37/2020. Thereafter, he has
You retired on?
37/2020.
Okay.
And
You
he
have
has
not
been-
got anything. Provisional?
Provisional he is receiving. Now the what they say is that his salary pay was wrongly fixed in the year 1996. That is why they have not released his regular pension. And during the course of this proceeding, the order dated 19/10/2022 will reflect that the ISS now refixed his salary with effect from 1/1/1996. Now they have to release the regular pension. We are not on the prefixation here.
What you want?
Regular pension.
You
They
have
re-
paid the 5,45,000.
No, they say that the excess drawal, excess drawal is not on the fault of the part of the petitioner. If they do not go for recovery, of course, they cannot go for recovery also. Now all they have to do is, as it is, they have refixed the pay with effect from 1/1/96. We are not disputing that. Whatever they fix is it now, they only have to release my regular pension in accordance with what they have fixed.
See, have you got your DCRG? DCRG?
Yes, other benefits we have received. Other benefits we have.
You have got your DCRG?
Yes.
Already that final pension has to be released. The PPO has to be issued, Lordship.
Yes, already.
That has not been done.
Lordship, I need 10 days further
No,
time.
it's okay.
Yes, Lordship.
I've got your
First,
point.
it was returned to
But
the
madam,
department.
tell me one thing. Without this court setting aside that excess drawal thing, there is most probably there must be some observation given by the director of pension saying that there is an excess drawal. And as such, that deficiency needs to be corrected.
No, there was a direction from the Director of Higher Education to the, Secondary Education to the inspector to determine whether the excess drawal was as a result of on the fault of the petitioner or not. And there is a finding after an inquiry that has been submitted by the Departmental Council that there is no fault on the part of the petitioner with regard to the excess drawal. It was due to the wrong fixation on the part of the departmental authorities. There was some excess drawal. So as it is, there is no fault on the part of the petitioner. That automatically they cannot recover. And also there is a Supreme Court judgment after retirement.
That's good, madam, but every time that is the problem. That is here you see the problem arises with Annexure 4, page 34. Pay of should have been fixed at rupees 4,600 instead of 4,000 a month, and subsequent regulation of the pay and so and so. Excess drawal be assessed with due and drawn statement and submit the same along with an assessment report regarding whether there was any fault on the part of the retired teacher for drawal of excess, so that we may forward the same to the government for waiver.
That has
So
come.
unless there
That
is
has
a
come. That has come. That report has come.
has the government waived it?
Perhaps also the department
yes.
has resubmitted a proposal after meet up all these deficiencies. So on that regard, I need to seek instruction.
Because there is a year of office memorandum of 2019 on following Rafiq Masih and says that to the effect that you cannot make this recovery from them at the time of retirement, 1 year or after retirement. You cannot make them on the question of wrong fixation if there was no fault. So it is on that this court has to pass an order to the effect that this
No, they have
is the wrong fixation is not the issue, not your problem. It has happened, and as such, directing them to make the payment. That needs to be done. Without that, how can you get? What you are saying is that he has submitted a report. Now, whether the government has waived it,
But that
Government has
was-
to waive that.
that-
And once the government waives it, the deficiency has to be removed. Then only the director of pension will remove.
That of course that they'll have to submit, but what we have come to know that there is no initiation of like, probably they have waived it because now recognize.
Madam, they don't do that. They don't go for initiation. They will lock your pension and thereby compel you to pay the money. This is how the modus is.
From the, let me bring the instructions for you. From the submissions which has been made during the previous year, it appears that they are on the process of issuing the PPO, regular pension payment order.
They are in the process of issuing.
That is what.
Okay, we give them time if you want that. No problem.
1 week is.
How much time?
10 days.
Mr. Esa Buru, the learned counsel, appearing on behalf of the respondent,
Number 6, Director of Pension.
appearing for the director of pension, 6, an accommodation of 10 days. Let the matter be listed on 3rd of April 2023.
Lordship, date.
3rd of April.
54.
May I please your lordship?
Yes.
Kindly, madam,
Which
maybe
department?
pass about for the time. Kindly, madam, maybe pass about for the day.
Mr. Adhar, where is he? Madam, if the matter goes out like this, you'll never get your relief.
Your lordship,
This court is not concerned with it. Dear. When this court has specifically asked them to find out why this payment has not been made to you, and if you seek an accommodation, it is at your loss. I'll give you 4 weeks for that. This is the matter of the 4 weeks.
item number 55, your lordship, same matter. Item
56.
number 55.
ঠিক man. Itu আগৰটো আগৰটো 55
55.
55 to the this is 56. We first take up 56, then we'll go.
Wait, please, your lordship. Lordship,
Yes, what instructions you have got?
lordship, we have not, actually, I have received some instruction, but it's not sufficient, lordship. From, because of this vigilance
An
case,
inquiry
all
has
the
come to learn that on the basis of an FIR lodged on so and so by one BN alleging some financial liability the name of the petitioner being So you have been charged with it.
Yes, sir. In a criminal case, I have retired in 2004. 2005, an FIR was filed. The case is presently at the stage of appearance of accused. And they are paying me, my lord, 8,840 as a lump sum. That why, from what they are doing, even provisional pension is not being paid. Now, Rule 20 of the pension code says that the government reserves the right to hold total pension or a part thereof only when I'm convicted.
Then
But in that view of the matter, my lord, like, cannot hold my pension, my lord. In this case, my lord, I am 79 years old. My wife is terminally ill, and 2005 FIR, my lord.
what you have not got?
My lord.
You have been only given provisional.
One amount is being paid only, nothing being paid. 8,840.
That I've seen. You have not got anything else.
My lord, gratuity, leave salary, DA, and regular pension, nothing, my lord. Rule 20, your worship, kindly see, only in a case I am convicted, my lord, government reserves the right.
Pension. Yes, madam, we have. I've passed a detailed order here
Lordship.
on 8/2/2023. As of now, why you have not made the payment?
Lordship, problem is that all the petitioners' documents is in custody of Lordship Vigilance Department. So there's because of the petitioner has not made a party vigilance as a party, Lordship. There may be some difficulty to press out this records.
That is between you and the vigilance.
Lordship.
Who is to pay the pension?
Lordship, department, definitely department.
Some vigilance have taken some documents out there. Does it make it that a person who is retired in 2004 has not been got the pension in 2023? 19 years have gone by.
Lordship, but 22 criminal proceeding is Lordship, is it trial stage? Lordship.
Huh?
Criminal proceeding is
So if
going
the
on,
criminal proceedings goes on, is it your case that pension cannot be paid?
No.
Is it your case?
Lordship, at present, Lordship, I have not received any instruction from department, Lordship. There's some difficulty to submit, Lordship.
Then madam, isn't this a fit case where the right? What about 20 future good conduct is an implied condition of convicted of a serious crime or of conduct.
Up till 2007, they paid the provisional pension. Thereafter, they have stopped and they have started paying some lump sum amount.
So we are into 20.
20, my lord.
So your basic case is that unless you are convicted,
my lord,
till then they cannot be withholding or withdrawing of the pension.
My lord.
And what does the pension department say? Where's the pension department? We have the pension department anywhere? No. Yes, Mr. Stroy. Is the PPO preparation of the final paper dependent upon a criminal case pending?
That cannot be, Lord.
Yes, the director of pension is a party.
No.
Yes. This court had made the director of pension on 8/2/2023. Mr. P. Soitia had accepted notice. Mr. Roy,
Lordship,
can you withhold the pension till a criminal case is finished? What will happen to the person concerned?
Lordship. Rule 21-22. Rule 21-22 says so if the Rule 21 and 22, Lordship.
21 is as regard departmental proceeding. 20 is
22.
that. 20 only says about conviction.
Provisional.
Provisional pension due to convention. Provisional pension 500, 22, under 22. 22. Payment of provisional.
But no,
No, there's,
during the period. Yes.
Criminal case pending আছে criminal case pending আছে
So yet to fulfill.
Now 21 is also if in a departmental or judicial proceeding, the pensioner is found guilty of grave misconduct or negligence during the, we are not concerned with this. It's a criminal offense.
Is a judicial proceeding will deem to be in case of a criminal proceeding on the date on which the complaint or the report of the criminal proceeding is included. Age. Age what?
AB. Explanation.
No, Lordship. It's
Rule 22,
Rule 22.
para 3.1.
1.6 H 1.
Page 15 of the book.
No, this is not, why you are going into the note? It is already there in the explanation of Rule 21. See, Rule 21 explanation B1.
Yes.
Yes, what should we do?
Well, Your Lordship, they cannot deny me pension and benefits for 2021, my lord. there has to be conviction, my lord.
And another aspect, if you see the note or even Rule 21 also, can a judicial proceedings be initiated on the basis of an FIR of 27/9/2005 when you retired in 2004 in respect to an event which happened in
2002,
then it is 3 years. Nah?
3 years. Then 4 years, it comes under that.
But anyways, can it be withheld in this manner? We'll take up this matter soon. When? When do you want it, madam? Why? 79 years old. You will laugh at a later stage. Why have I come to the High Court? I've already given you 1 month. Then, and that too by a detailed order, making it clear what is the consequences. We'll have it on 28th of March. You just find out if there is any judgment on the point on this 20. There might be similar there. All these pension codes are all same of all states.
2007 CGLR, I'll produce your lordship. Equally on this point. I'll come with
So
it.
we'll dispose it off on that day. This can't go on like this. With the heard Mr. B. Chakraborty, the learned counsel appearing on behalf of petitioner. Mr. G. Bora appears on behalf of the respondent number 1 and 2. Mr. Mr. S. Roy. S.S. Roy appearing on behalf of the director. This is the matter again on 28/3/2023, on which state an attempt shall be made to dispose of the matter at the admission.
My lord, registry will reflect a GA Assam lordship, otherwise we will GA Assam name may be reflected in the copy.
The registry is directed to show the name of Mr. S.S. Roy, the learned counsel appearing for the director of the request of the learned counsel methods and John Pope.
$57.
May I please, the lordship?
For this matter?
My lord, it's with regard to removal of a register of
I
my lord
remember.
Hattadev. My lord, there was an interim order passed by my lord.
It's a long order.
My lord had protected me. They had issued an advertisement thereafter. My
I've
case
seen
is
the
it is
advertisement.
punitive in nature. It's punitive in nature, my lord, because I was involved in a criminal case, so they have done it. So they have filed an affidavit, my lord. Unfortunately, it's may not be on record. The university has filed an affidavit.
Has got the affidavit here.
Affidavit,
Additional affidavit has been filed by you.
my lord, no, no, my lord. The affidavit by the respondent number 3, 4, and 5.
You are there.
He filed.
I'm for the respondent before.
You have filed the affidavit.
Day before yesterday.
Then why is it not on record?
He filed it on, my lord, 14. No?
13.
13, I mean 14.
I've asked you to file the affidavit on or before 27/2/2023.
True, my lord, but certain,
Then why have you filed so late?
my lord, certain instructions were required, my lord.
Then,
So those instructions are readily not available.
then if you require instructions, then why have you taken up such actions so fast? If you don't have instructions,
My lord, the records were also called. So my lord, after everything was in order.
you got the records? Let us see. Has the respondent number 8 filed any
No,
affidavit?
Lordship, 10 days time, Lordship, for filing a
Why?
affidavit in opposition, Lordship. So that I've got the instruction, Lordship. Some time will be required, Lordship.
For what?
Respondent number 8 was out of station, Lordship. But
So?
that's
This
why
court directed to file the affidavit on or before the next date so fixed.
Today is our first day, Lordship.
In fact, the matter was supposed to be listed on 28/2/2023.
It was
Why the
listed
matter
by-
has been fixed today? Oh,
My lord, it
Was it listed?
my lord.
No.
It was listed, but maybe.
We should ask the registry why the matter has not been listed.
It was listed.
Listed.
It was listed, but it could not reach.
Oh, it didn't reach. So what to do now?
Well, let me take up next week for final disposal.
So we'll accept the malafide allegation against you to be true.
No, Lordship, that's why, Lordship, I submit one affidavit in October.
No, you just
affidavit in
said
opposition,
yes when he said next week.
No, no.
Then
The serious allegations are there, Lordship.
So that is why
Not, Lordship.
this court had directed you to file the affidavit.
Lordship.
Why haven't you filed it?
7 days time, Lordship, I will have.
Because whatever may be, this court had stayed the advertisement.
We have issued a corrigendum. And saying that
No, understood. But when staying the advertisement, the post of the chief executive
so post of register.
administrative officer has been stayed.
Post of register.
He's the chief administrative officer as per your regulation.
Yes.
So that has been stayed. That is the reason why I've given reason also. In terms of the first statute, so and so, this aspect could be seen from a perusal of section 4.2, which stipulates that the registrar is the chief administrative officer of the university. Understood that this court to direct the respondents to file the affidavit on or before and also produce the records on the next date. You got your records?
Fine.
Now, what has happened to the other matter?
The other matter is pending. Suspension matter.
The suspension matter was also listed, my lord, few days back, but it did not reach.
Before this court? You file your affidavit by 27th of March. And Mr. Nair, you file your reply, if any, by 30th of March. We take up the matter on 4th of April.
4th of April.
With liberty to mention. Agreed. Heard Mr. UK Nair, the learned senior counsel, assisted by Mr. H.K. Das. The learned counsel for the petitioner. Mr. J. Patwari appears on behalf of the respondent number 3, 4, and 5. And
A Chakraborty for
A.
respondent.
Chakraborty appears on behalf of the respondent number 8. Mr. P.J. Phukan appears for respondent number 6 and 7. Are you filing any affidavit? Mr. J. Patwari, the learned counsel appearing for the respondent number 3, 4, and 5 has submitted that the affidavit on behalf of the said respondents have been duly filed. Mr. A. Chakraborty, the learned counsel appearing on behalf of the respondent number 8 submits that he requires another 10 days to file the said affidavit on behalf of the said respondent. Let this matter, taking into account the said submissions, the respondent number 8 is to file the affidavit on or before 27th of March 2023. The petitioner, if so advised, shall file their reply to the affidavit filed by the respondent number 3, 4, and 5, as well as if any affidavit is filed by the respondent number 8 by 30th of March 2023. Let this matter be taken up for final disposal on 4th of April 2023. The respondent number 3, 4, and 5 is directed to produce the records on the said date. A liberty is given to the petitioner to mention the matter for upgrading.
58.
Made clear. Instruction was taught for mother. He is a casual worker mother. He retired.
Yes, why haven't you paid the pensionary benefit?
Lordship, this matter relates to Kobrajar Lordship BTC. There is a standing counsel for that.
Where is BTC? You are there?
I'm for the accountant general.
Mr. No. Where is Mr. B. Gogoi? No BTC. No B. Who appears for a BTC? S.R. Rabha. He was appearing. At Mr. G. Boishkar, the learned counsel appearing on behalf of the petitioner. We're appearing for whom?
I'm for the respondent number 3, Lord.
Name?
Which is the principal chief conservator of SM Hassan, Lord.
Mr. SM Hassan appears on behalf of the forest department.
Lordship, PCCF, respondent number 3, Lordship.
What is that?
Lordship, principal chief conservator of forest.
So it's the forest department?
Yes, Lordship.
For the forest department. Miss?
I'm for the respondent number
What's your
7,
name?
accountant general. J. Das.
When so appears for the accountant general. None appears on behalf of the PTC, finance, as well as the case of the petitioner hearing is that the petitioner had rendered more than 30 years of service as a master role worker But he has not been paid any pension or pensionary benefits by the respondents for which the petitioner had approached this court under Article 226 of the Constitution. This court, by the detailed order dated 13/2/2023, has sought for the instructions from the respondents as to why the petitioner, after having rendered 30 years of service, have not been granted the pension as well as the pensionary benefits, in spite of the fact that there is an office memorandum dated 6/9/2023 issued by the Secretary to the Government of Assam Pension and Public Grievances Department, where it has been mentioned that the government servants rendering 20 years of continuous service without being confirmed shall be eligible for pensionary benefits. None of the respondents have filed their affidavits, nor the respondents appearing on behalf of the BTC as well as the finance are present before this court. Taking into account the same, this court fixes this matter again on 22nd of March 2023. And if the respondents do not apprise this court as to why the petitioner is otherwise not entitled to pension or pensionary benefits, this court would have no other option to grant the pensionary benefit grant in terms with the office memorandum dated 6/9/2003. List the matter accordingly. Liberty is given to the petitioner to mention the matter for upgrade.
59.
Yes. Mr. SM Hassan, tell me.
Lordship, in this matter, Lordship, I have received the instruction, Lordship. As per instruction, we have to first regularize the suspension period, Lordship. First, regularize the suspension period. Lordship, for that, we are taking steps, Lordship. And moreover, there is a DP pending, Lordship.
Appeal pending?
Against the petitioner, Lordship.
For what?
He was arrested also. As per order dated 26/11.
Understood. What is he asking for?
Lordship, area salary, Lordship.
For the period?
For the period,
what is this area salary business?
Lordship may come to page number
7, para 10.
Page number 7, Lord. Para 10, Lordship, page number 7. Lordship, we have already paid the subsistence allowance, Lordship, and moreover, we have also paid almost 75%. A mere small amount is left, Lordship.
No. Now, what is happening out here? Pending trial, this so and so is suspended, is hereby reinstated with immediate effect and in the interest of justice. Now, what is his claim?
Lordship, he is asking for the area salary.
Similar.
What is your claim?
I claim, my lord, 1,52,000.
No, understood. That I've seen it from paragraph number 10. You are asking for
Salary of suspension.
that salary for that period.
Yes.
Minus the subsistence allowance which you have already received.
Yes.
But whether it has been held that this period has to be treated as a period on duty.
My lord, petitioner already submitted application, my lord, to the respondent authority to regularize the suspension period for the purpose of area salary.
Now, have they done it?
No.
Then?
They have not done, my lord.
Then how does your entitlement arise?
The petitioner will take suspension retirement on 31st March, madam. Only left in this.
What is that?
Lordship may see serial number 6, Lordship. Next page.
But Mr. Counsel, unless and until the said period is treated as a period on duty,
Yes.
are you entitled to?
My lord, yes, sir, my lord. On that count, petitioner submitted representation.
Understood.
Yes, madam. That was-
You have submitted representation to treat it.
Yes. Only 15 days left for retirement.
Huh?
Only 15 days, madam.
Understood. You will
Okay.
obviously get back whatever it is required, whatever is entitled to, but without being done. Because you are asking for area salary. How can there be an area salary if that period is not treated as a period on duty?
Yeah, my lord, they may be directed to regularize the period, my lord, as per law, madam.
Huh?
And that period may be considered, my lord, as per law, my
But
lord.
that is not your prayer. That is not your case at all.
Yes.
How can I help you on that? Your right will only accrue
Yes.
once you are being treated on duty.
Only, my lord, only 15 days left for
Understood.
retirement.
But can this court direct on that aspect? You are entitled to, you will get it, or whatever may be. But how can it, as of now, it be said to be an area? Isn't it, Mr. Hatta? Hmm.
Moreover, TP is there. Lordship, TP is pending, Lordship.
Forget about the DP. DP may be there, but sometimes this period is treated as a period of duty also.
Yes, sir.
Then how can you be entitled for that? Unless there is an order. Can't help it, Mr. Counsel. I can give a direction to that effect for consideration of your, is the representation here?
My lord, here is, this application is not here, but others application is here, my lord.
I can't help you there also.
Others application is there.
Huh?
Others application is annexed in this retreat. Page 21 order.
Can't help it.
My lord, I have stated in paragraph 11, my lord, the petitioner
Understood.
also submitted
Have you
application-
stated anything?
The petitioner also submitted application for regularize the suspension period for the purpose of release of the hair.
But that is not the relief you have sought.
Yes, my lord, only my lord, 152,000.
Anyways, okay. Let me.
Sometimes.
Heard, Mister, your name?
KM Ahmed. KM Ahmed.
KM Ahmed, the learned counsel appearing on behalf of the petitioner. Mr.
SM Hassan.
SM Hassan appears for the Forest Department. The case of the petitioner herein is that the petitioner was put under suspension by an order dated 26/11/2021 on the in terms with Rule 6.2 of the Assam Service Bracket Discipline and Appeal Rules 1964. The petitioner it may be relevant to mention that the petitioner was arrested in connection with Lamding PS case number 224/2021, registered under section 147/426/326/506/307 Indian Penal Code, read with section 24A B /25 A B C D F /42 B /61 of the Assam Forest Regulation Act. Let's check out. The petitioner thereupon was granted bail by this court in bail application number 3455/2021 by an order dated 20/12/2021. Subsequent thereto, the petitioner challenged the suspension order on the ground that the petitioner was not served the memorandum of charges the charge sheet by way of a writ petition, that is WPC number 3380/2022. This court, by an order dated 27/5/2022, had set aside the said suspension order on the ground of violation, on the ground of being violative of the judgment in the case of Ajay Kumar Chaudhary versus Union of India, reported in 2015 7 SCC 291. Thereupon, the petitioner was reinstated by an order dated 15/6/2022. Pending trial of departmental proceedings. It further appears that the petitioner had thereupon submitted representation on 21/7/2000 on 21/7/2022, 17/11/2022, as well as on 19/12/2022, for treating the said period of suspension as on duty, which is however pending before the Office of the Divisional Forest Officer, Dhemaji Division, Dhemaji. The case of the petitioner herein is that the respondents have not disposed of his representations. And if the said period when he was suspended, during which period, if the period during which he was suspended is treated on duty, the petitioner is entitled to an amount of rupees 1,52,078. The details of which have been given in paragraph number 10 of the writ petition. Claiming the said amount, the incident writ petition has been filed. I've heard the learned counsels for the parties from a perusal of the materials on record. It appears that although the petitioner was reinstated on the basis of the order dated 27/5/2022, passed in WPC number 3380/2022, by an order dated 15/6/2022. But the said period of suspension has not been treated as a period on duty. Consequently, the question of there being any area salary in the opinion of this court does not arise till the said period when the petitioner was on suspension is treated as on duty. Under such circumstances, the question of issuing a direction to the respondent authorities to pay the amount of rupees 1,52,000 so and so as area salary does not arise. Be that as it may, the petitioner duly have a legitimate expectation for consideration of his representations for treating the period of his suspension as on duty. Under such circumstances, this court therefore disposes of the petition with the direction to the Divisional Forest Officer, Dhemaji Division, so and so, to consider the representations submitted by the petitioner on 21/7/2022, 17/11/2022, and 19/12/2022 within a period of as expeditiously as possible. More so taking into account that the petitioner is going to retire on 31/3/2021, 23. The said exercise be completed within a period of 3 weeks from the date a certified copy of this order is served upon the Divisional Forest Officer, Dhemaji Circle, Dhemaji Division, na? Dhemaji Circle,
Dhemaji South Division Road.
Dhemaji South Division, Dhemaji Dhemaji Division, Dhemaji.
Dhemaji Division. Yes, 9.
From the date a certified copy of this order is served upon. It is made clear that in the if the said authority treats the period of the petitioner's suspension as on duty, the petitioner would therefore be entitled to the full salary, the salary during the said period after making the appropriate deduction on payment of the subsistence allowance. With above the petition stands.
Item 60.
Yes, master roll worker, regular employee in his retirement on so and so. Case of the petition is the pension people who are submitted to concern.
May I please your lordship? Lordship, I'll seek an recommendation, Lordship.
Huh?
Lordship, we have not received instructions. We have written the department. Lordship. Sometime may be granted.
How much?
3 weeks. 3 weeks.
Three weeks doesn't look nice.
Lordship, as per your lordship.
2 weeks. Mr. S. M. Hassan, the learned counsel appearing on behalf of the Forest Department submits.
Lordship, PhD, Lordship.
A PhD department submits that he requests some accommodation in the matter in view of the fact that the instructions sought for by the order dated 22/2023 has not come from the said department. This court fixes this matter on 29th of March 2023. On which day the standing counsel for the PhD department shall obtain the necessary instructions in terms with the order dated 22/2023.
Hello.
62.
Liberty is given to the petitioner to mention the matter. Well,
Very
yes, Mr. Dekar.
Your lordship, will you please to see the last order is 27th of February, Lordship. Lordship, I have received instruction, my lord. As per my instruction, my lord, the matter is under process, my lord. So I pray some more time. In the meantime, on 1st of March. Director,
How much time?
3 weeks, my
You have retired? No, no, area salary.
Areas, right, for peer lordship, and it's the annexer 10 lordship,
Huh?
17, annexer 10, page 26 lordship.
Ah,
Yeah, lordship, already proposal has been given lordship, shown the head of the account lordship. Now matter is pending before the director lordship. Director as well as the commissioner. 17/11/2022, and page 26, annexer 10.
On this proposal, my lord, this letter is issued by the
Mr. B. Talukdar, the learned counsel appearing on behalf of
elementary.
the Elementary Education Department, 6 for an accommodation of 3 weeks to apprise this court as regards the status pertaining to the area salary of the petitioner for the period from 1/1/2013 to 28/2/2014. He further submits that on 1st of March 2023, the Director of Elementary Education Assam have already taken up steps with the District Elementary Education Officer Morigaon to list the matter again on 5th of April 2023, on which day the learned counsel, Mr. B. Talukdar, shall obtain the necessary instructions.
Okay.
A copy of the instructions so produced by Mr. B. Talukdar is kept on record and marked with the letter X.
65.
Liberty for application.
Liberty is given to the petitioner to mention the matter for appeal.
If level.
Yes, Mr. G. Bharadwaj,
May I please, sir?
you are not. Yes, tell me,
Lordship, we have filed an affidavit, but it's not shown in the record.
who has filed it?
Petitioner,
For what?
that's the service.
Huh? No. Where is this? Respondent number 1 and 2, Mr. A. Chakraborty. Where is he? Urban Development. And what about Howley? Howley, you have got it, sir?
Respondent, sir?
Howley? What about the Howley? They mentioned notice has been issued to respondent number 320. Okay, notice upon respondent number 3. Justice service is received on 20. Have you taken steps?
Lordship,
Then what happened?
we have filed an affidavit on 13.
On
13.
affidavit of service?
Yes.
Okay, very well. Now, why you have not been paid the salary of PPF, GPF and Iman by the Howley? Oh, now without Howley, we cannot do anything. And your affidavit is not there on record. Let the matter be listed again on third of April 2023, along with an updation of the service meted out to the respondent number 3. Liberty is given to the petitioner to mention the matter for appeal.
Supplementary item 66.
Yes. You have submitted the termination order. So you say that it is an illegal appointment.
And yes, my lord. And she was terminated on 5/8/22.
5/8/22, yes. And then?
And she's claiming her salary after that, my lord.
Oh, is it so?
My lord.
Are you?
Lordship, unless and until a person aware about his whatever happened with him, how he can determine that what have been happened with him? Lordship, since the termination order has not been communicated, neither it was published, nor any so-cause notice has been issued to the petitioner. I think before issuing this termination order, the Supreme Court recent judgment Rana Pratap Singh, that has to be relied on, because unless and until an appointment letter has not been challenged for a long period, it subsequently cannot be said that it was an illegal appointment.
My lord,
that point is very
he
much
has to
clear.
challenge his
Lordship.
order, my lord. Unless he challenges his order, my lord, he has
No.
come here in this
When I will
petition
challenge?
for
When?
for the
Lordship,
pending salary. We
Lordship,
said that he was not in
then
the office.
Lordship, State of Punjab versus Amar Singh Harika, they have Lordship, this document has no value, Lordship, because this Honorable Supreme Court has clearly says in the year 1966, Lordship, that. May I read, Lordship? The first question is, which has been raised before us by Mr. Vishan Narayan, is that though the respondent came to know about the order of his dismissal for the first time on so and so, may I read the relevant portion, Lordship?
Please.
We are therefore reluctant to hold that an order of dismissal passed by an appropriate authority and kept on its file without communicating it is to the officer concerned, or otherwise publishing it will take effect as from the date on which order is actually written out by the said authority. Such an order can only be effective after it is communicated to the officer concerned or is otherwise published. It is not a valid document, Lordship. Feel that it was served. It has been served to me before this honorable court.
My lord, it is, if I go by the document, it is addressed to her only, my lord.
So
now, my lord, whether
is it the process, Lordship? What is the principle? What is the basic principle of issuing a termination order, Lordship?
now she says that she hasn't received it, my lord. So only, my lord, the record will reveal. I have to, what I can do is, my lord, I can get the record how it was served to her. That part.
Issue has come when I have claimed for promotion, Lordship. 18 years I have continued service. There was no dispute that my service was illegal. When I have claimed for promotion, at that time, the issue has, they have raised that issue.
Then
why they have ever waited for last 18 years?
My lord,
still till today, Lordship, they have utilized my service. Till today.
You're still serving.
Yes, your Lordship.
How?
I don't know, my lord. This is, my lord, what I got the instructions, my lord. If
I have been terminated, Lordship, at least they could have to challenge, review that order, Lordship, that was passed by this honorable court, Lordship.
The lock and key is with him. How is he functioning? How is he functioning? It's if you have terminated.
My lord, she is an Anganwadi helper, my lord. So I do not know, my lord, how they are, my lord, managing the office. But this document says that she is terminated. That is what, my lord, I'm stating, my lord. So only now the thing is that, my lord, what I can do is whether she is into service and when this was, my lord, served to her, that I can, my lord, get back from that authority. That part, my lord. Now she is claiming that she hasn't received this termination letter. So some way they would have, my lord, communicated. How it was communicated, that I have to find, my lord.
You let the child development project officer, Dhokwakhana, file an FIR.
My lord.
What do you say?
Yes, my lord. With how it was solved, that we will bring on the court.
Isn't it? Mr. T. Sharma, the learned counsel appearing on behalf of the petitioner, Mr. Ardhidhar, appears on behalf of the respondent numbers 1 to 6. Mr. Dhar today has produced a letter, a termination letter dated 5/8/2022, whereby the Child Development Project Officer, Dhokwakhana ICDS project, have terminated the services of the petitioner with effect from 5/8/2022 on the ground that his or her appointment was illegal. Mr. T. Sharma, the learned counsel appearing on behalf of the petitioner, submit that till date, the petitioner have not yet been served with any termination letter. And as of today also, the petitioner have been rendering service in the said Anganwadi Center. Taking into account the same, this court finds it appropriate that the Child Development Project Officer, Dhokwakhana ICDS project, who is the respondent number 6 in the instant proceeding, is directed to file an affidavit bringing on record the order dated 5/8/2022, the communication dated 5/8/2022, as well as also stating the said affidavit as to whether the termination letter dated 5/8/2022 have at all been served upon the petitioner, and if so, when. Further to that, the said official is also directed to place on to put it on affidavit as to whether the petitioner is still working in the said Anganwadi Center as on date. List the matter after 3 weeks. List the matter on 25/26/2023.
Milo 25, Milo.
26. Take on grade. I'm not keeping this.
Highly object.
Item 44.
Such employee, my lord, in PWD department, like
Mr. Ardhar seeks an accommodation.
My lord, I have filed a affidavit. It's on record, my lord.
Okay. What are you saying?
My lord, he has received some money in para 6. You have stated, my lord. He received some 4,280 and 68,000 on 2 accounts, then 8 lakh. But here, my lord, he is on the pension, my lord. My lord, that is what he was engaged as a work charge, my lord, master role and work charge employee, and work charge employees are not entitled to get pension from which the applicant has not been awarded pension. He was not regularized, my lord. If government takes, and we said that if the government takes the decision, we will all give him the pension. But as of today, my lord, he is not entitled. That is what we said, my lord. In page number 31, the last paragraph, my lord.
So
Further
you
in
say
the,
that he is not regularized.
further in regard to regularization of his service, it is mentioned that the service of master role, labor and work charge and other similarly situated employees who had engaged on or before 1/4/1993 are to be regularized by the government. As per the present rule, the work charge employees are not entitled to get pension for which the applicant has not been awarded pension. So that is the stand, my lord.
But what do you say about the 20 years of service? as per that
26,
office
my lord,
memorandum
26
of
years, 4
2003?
months.
Regularized means either the appointment has been irregular. Maybe not on vacant post or something like that. So under such circumstances, what do you say about that particular office memorandum? You're a person who have rendered more than 20 or more than 20 is entitled to pension.
My lord, but he was not regularized. That is the thing.
Understood. Is it regularization required?
Master roll worker, my lord, those who were regularized in 2005, my lord. Only.
Let us see this.
Attention.
What do you say about this office memorandum of 6th of September 2003? Page 190. This is the basis on which this Sanjita Roy also had happened. Now, what you did, this was this particular notification.
Sanjita Roy, my lord, in Sanjita Roy, my lord, those master roll worker regularized.
No. Sanjita Roy, there was what happened 20 years.
20 years
is required, but what you were doing, you were adding another 6 years.
My lord.
The High Court said that no, you can't add the additional 6 years. And as such, held that that is bad. But a person who is otherwise working out there for 20 years, not in sanctioned post,
not in a sanctioned
without being confirmed. Then,
my lord, those workers were, my lord, regularized. They were sanctioned. Personally became the personal post. But here, my lord, he is
regularization will be required for family pension. See 140, 139 or 140.
my lord, in those batch of master roll workers, they have joined prior to, my lord, this 93. And here this petitioner, he has joined on 38/1994. Maybe that's why he was not regularized. He did not fall in that batch.
No, no. It is only the question of 20 years.
My lord will fix the matter for final disposal day after tomorrow, my lord. Day after tomorrow or Monday, my lord. I will satisfy the court.
In fact, if you see the old pension, new amendment also, not to 28, which have been brought in, this office memorandum still remains. as I was dealing with this old pension, new pension,
Yes, madam.
I think this office memorandum still remain. Because what has happened by this 2A, what you have done is those persons who have been into the government service after into a pensionable establishment, appointed to a pensionable establishment. So the new pension scheme does not, this office memorandum still survive. Anyway, I'll keep it when after vacation.
My lord, fix any week. Next week, even I have no problem. Or after vacation, my lord.
No, I have a problem. So many matters are being fixed.
My lord, my lord will fix the date.
And Mr. Das is also such a busy council. You have to.
No, my lord, I am always free.
You want to file a reply? No.
No, my lord.
Leaving to incomplete, let the matter be listed again on 24/2023, on which date an attempt will be made to dispose of the matter.
45.
My lord, my lord, the petition not appealed drafted, my lord, yet the petitioner was appointed as the my lord, Gaubura, and there was some allegation against him by one person, and he was in that allegation it was said that his social was false, but later it appeared to be genuine. Anyway, my lord, and there was a criminal case filed against him. He obtained bail. This court protected him by giving anticipatory bail. And he was suspended on 1/12/2021. Now it is 1 year, about 4 months. And my lord, proceeding to my knowledge has not been initiated yet.
1/2/2021, what is what? You have been suspended or
Yes,
what?
yes, suspended. Yes,
When?
Page 25.
Page?
25, my lord.
DP has already been initiated, Lord.
Initiated.
Gambura is a government servant.
Yes, my lord. Civil servant. Public servant.
It's a civil post, Lord. It is not a government.
1967 Supreme Court, my lord.
64 rules apply.
Yes.
But the departmental proceeding is initiated under 64 rules. I
It
have
has
that.
been done.
I have documented. Yes, Lord. It
That's
was
it, even.
initiated and next date is fixed on 28/3/2023. And that.
And what
DP
are
is-
these two documents? Order dated 1/2/112 is a suspension.
Yes.
And then representation is being submitted.
Yes.
Then
Then
nothing remains.
nothing remains. Nothing means that.
And on the basis of an inquiry conducted, Lordship, he was put under
Let us
suspension.
see it now.
And thereafter, Lordship, DP has already been initiated. So, Lordship, if he is aggrieved with the DP, he can come again. But regarding suspension, that part has already over.
I don't know. I have not got instruction on whether start season served on me or not. But let it come on Monday or Tuesday anyway. If the task is submitted, let me get instruction. Otherwise, they'll let them.
No, he is on suspension.
I mean,
Now DP is initiated. If DP is initiated wrongly, he can come by way of
there
an
is, there is
Understood.
subsequent.
But have you initiated, issued him the memorandum of charge or not? Have you done that?
Lordship, I have received the instruction that DP has already been initiated, one that had already been gone, and next date is fixed on 28/3
All right.
of
For
this
what?
month
For what?
for hearing.
So inquiry officer has been appointed?
Yes, inquiry officer, presenting officer appointed.
So
So
that
if,
means you have replied.
My lord,
If the 64 rules have to be taken into account.
yes, I am to reply.
No, you have already replied. Then only the inquiry officer is appointed.
No.
Yes.
Let me get instruction because,
Sir, Mr. Sharma, kindly have a look.
yes,
Line
I know,
four
my lord.
categorically
Rule
says,
9, yes.
once the memorandum of charge is being given, you submit a reply.
Yes.
And then the government will take a decision appointing the disciplinary authority as to whether they will do it by themselves or appoint an
Yes.
inquiry officer.
Under rule
And
9.
when they appoint an inquiry officer, along with that, a presenting officer will be there.
Yes.
Meaning thereby that a memorandum of charge, your reply has already been submitted. If it is the case where he is to appear for hearing.
Then can you be my lord, take tomorrow? Then? Let me get instruction. Tomorrow. I got no instruction that task is stopped or not. That is not in the.
There's no stay.
No.
Okay, we'll have it after 4 weeks. Then we'll say the matter has become infructuous.
No,
What
my
is?
lord. Then my lord, let it run Monday, my lord, for that. Monday will be certain full time. and your
No, the
lordship will-
person concerned have not contacted you or your junior colleague.
Let it Monday, my
In
lord.
fact,
then
you have
they-
not been instructed, Mr. Sharma. Okay,
Because
and the matter will listed again on 22nd of March, 24th of March.
Okay.
At the request of the learned council for
much obliged.
47,
Oh, this matter.
My lordship may have the clarification that I've got.
You have stopped the salary.
My lord,
Salary has been stopped.
salary has been stopped. In fact, my lord, as far as the private respondent is concerned, my lord, his appointment itself is illegal. That we have now, upon verification, we have found.
Yes, what have you done?
My lord, in fact, my lord, the authorities are contemplating to initiate some disciplinary proceeding against the, my lord, erring officials in the district.
Great. Something good has happened. That is very much necessary. Nowadays, that is the problem.
My lord,
The
regarding that, my lord,
sufferer is the person who is getting the service and not by the person against who has made him to suffer. Copy of the copy of the selection list approved by ATC come in demand.
lordship will see para 5 and 8, my lord, everything will be clear.
The budget allocation of the who is Noor Alam?
The private respondent. my lord.
So the petitioner did not attend from July 2021 to March 2022.
My lord, that is a specific.
As per the report of so and so. Yes, Mr. Sinha. First of all, what is your right after this 8 days?
The first day of itself, my lord, I have submitted regarding that. That, my lord, once the contract period is over, then also I was working.
So what?
Then also I was working and I was paid on honorarium also.
Very
and,
nice.
And the period that they were mentioning, my lord, after July, after that period, my lord, why I was, my lord, even though I have attended, I could not sign because the respondent number 4, the BEO, he stopped me. He stopped me and he did not allow me to sign the attendance register. Although
But
I
you
was
were
working.
still working.
Oh yes, I was working.
You
He did
don't
not
find
allow me
people
to
out
sign the
there-
register.
People out here is not working after signing, and you are without signing also working.
But this is my instruction, my lord.
Ah.
This is my instruction. That
And you are nowhere. Because of you now that DEO, what is the DEO or BO?
BEO, my lord.
BEO is in a soup. But tell me, how can this court direct for payment when you don't have an agreement?
But first of all, their stand has to be first clarified whether it ought to have been for 11 months or it ought to have been for
They
this
are
period.
saying it should have been for 11 months.
Yes,
but taking into account that your appointment was on 23rd, at the end of the period, you were only given for 11 days.
Then, my lord, why I was given the honorarium after the period of the contract period?
You
Because
want to return it back? No, if you want to return it back, you say you will be happy.
Because they have
Mr. Gogoi,
utilized
you
my
will be happy, I
services.
suppose.
My
You'll
lord,
be
they
happy.
have utilized my services because of which they have paid me
Who has
honorarium.
asked you to? And thereafter, from July, you have not utilized your service. Nobody, there is no matter, nothing on record.
They have, my lord. I have categorically stated in my writ petition paragraph
So
9 that
what? They have stated out there, no, you have not worked out there. Then
it is the BO who is the mischievous person out here, my lord. And because the BO, I couldn't sign the register, but I was working.
no. What do you expect this court to be a fact-finding inquiry? No, tell me, what is your right to get a salary? Will be dependent upon an agreement, a contractual agreement between you and the state, or an instrumentality of the state. Now, that agreement is there for only 8 days or 11 days.
38 days.
38 days or so. And you have got more than that. You should be happy. And because of you, the BO goes now to that you also have some grievance against the BO. So the BO is also in a soup. I hope they take steps against it. Yes, are you taking steps against the BO?
Yes, yes. That is a specific instruction.
No,
I have.
See, it is something like you got dinner and then after that a good dessert also.
If that be so, my lord, may I pray, my lord, that I am the person, my lord, who has the, my lord, highest marks as well as experience. If they are going to consider or they are going to take person as an educational volunteers, then my candidature may be considered by them because they will be requiring educational volunteers.
But You mean to say that this court to now
Well, only
change the standards of recruitment? They have an advertisement. Is it based upon the consideration
because, my lord,
or have you crossed the?
what if at all, my lord, if they have followed the rules, my lord, then we would not have come before this honorable court. my
Let
lord.
us assume that it was 11 months.
Yes, my lord.
Then also you got your salary till July.
Yes, my lord. Then I will be getting till March 22. Till March 22, I should be getting if it is extended till.
But you
March
have not worked from July.
my lord, as regards that, my lord, I cannot help because my instruction is that
Neither I can help you.
my instruction is that I have worked, but the BO has stopped me from working.
BO likes him,
Yes, my lord.
and for him, BO now will be facing departmental proceedings. Is the job so lucrative for the BO to? This is salary is 5,500. For that, the BO will lose his job.
Because my lord,
Sitting out here in this bench, this court gets always surprised every time.
because my lord, the initial order was passed by BO only, the 23/2/21, which was stayed by this honorable court first on the day when the writ petition was moved. Parallelly, he has
Now, Mr. Gogoi, what are you planning to do?
Well,
I
so far as the- Yes, madam.
Yes,
So
what
far
are
as
you
the
planning to
private
do?
respondent is concerned, madam, we have categorically stated and there is a.
No, that is
finding
illegal, you have stated. Then you're not only illegal, what he has done is too much.
Too much.
Giving them contractual appointment for 60 years.
Not-
Too much. Then
Now, my lord, whether they will be again recruited or not, well, that part, my lord, or if your lordship give a direction or some observation.
for what?
That if at all there is advertisement, because the petitioner is aged 28 years only, isn't it? Or at the time of filing of the petition in 2022. So he will be within the age limit. If it is advertised, my lord, some. Because apparently, my lord, she has been deprived from her, my
No,
lord.
what are your rules for recruitment?
That lordship may see that Pant have given, my lord. There is a guideline.
How is it to be done?
It will have to be through advertisement. Lordship will see, my lord.
Deed of
Process of
agreement
selection
on
of
so-and-so will be signed between
selection of
so-and-so and
education
be
volunteers
effective
for
from the
new
date of
so-and-so as
signing
per the
the-
following guidelines. My lordship will see applications will be invited with attested. copies of-
Where? Hey,
The guideline is, my lord, 22/12/2020. The annexure of the
22,
Paravas
12.
Women, my lord.
Yes, I
Now,
got
in
it.
the second page, at the
Second
top,
page. Application will be invited with attested testimonial from eligible candidates for the notified future of email.
the concern
Will give wise
SMC is a school
publicity to notice
state,
of the concerned important
school management
landmarks of the
society.
month when minimum
School
age
management
limit up to 50 years. So you got another 22 years.
lordship. Thereafter, my lord, the board has been given, my lord. Who will be the board
The job
selection?
will
board?
be purely of temporary nature and schematic only. The entire agreement will automatically on the completion of the agreement period. No demand for further extension will be entertained. No claim for absorption in other positions at any levels will be entertained in future.
Then thereafter, in the next page, my lord, lordship will see the list of selected candidate will be sent. to
But
the-
what do you see the next page? Kindly see the deed of agreement,
Lordship.
the last page.
Yes, my lord.
Deed of agreement on 1st of February 2021 will be signed between so and so, and the agreement period will be effective from date of signing till 31st March.
31st March. As per.
That means what? 2 months.
Well, here again, my lord, yes, so far as this guideline is concerned, that my lord, 31st March 2021, that period is indicated.
Understood.
Thereafter, it will be extended next year.
No, but you can't extend this, no? You see, only this will be as per the agreement. You see, kindly see here. And the previous page, number 4, the entire agreement will automatically terminated on completion of the agreement period.
My lord,
No demand for further extension will be entertained. Get it?
my lord.
Now, how do you reconcile with this?
First February to, yes, in fact, the year has been indicated, my lord.
Then?
The next, my lord, next bullet point, lordship may see, the select list of the candidates will be valid only for 1 year initially. Initially means, my lord, it will be subsequently extended as court, my lord. If the candidate is resigned or released from the job, the next candidate in the merit list will be engaged. For filling up a vacancy will be done at district level, at district level with prior information of concerned deputy commissioner. That's why.
So you will have that particular select list will be valid for 1 year.
My lord.
Now tomorrow Mr. Sinha goes out, the number 2 will be taken up.
Yes.
It's okay, that I understand. But how do you reconcile that? The deed of agreement on 1st of February. We have a new guideline.
No, my lord. According to them, this is the, my lord, one who is holding the field.
But this doesn't say that. Where do you get this 11 months thing?
Lordship. Probably, my lord, this was issued for that particular year, my lord.
No, in fact, the advertisement, if you see, was only for 38 days.
Yes, very specific.
See the advertisement. And his appointment letter is also there. Here, if you see in the petition, if I remember correctly,
Lordship.
see the advertisement. Advertisement doesn't say anything, but then if you see his appointment letter,
Page
16.
it makes it clear 22nd February to from 22nd February to 31st March.
Exactly, my lord, as per this particular bullet point. Yes.
So what is your, how are you saying that he will be there? And that is why his agreement is also ends on 31st March.
Yes, yes.
But after that, my lord, if my lord sees my lord next point, my lord, the selection.
No. Might be, my lord, for each year, my lord, there are separate guidelines are issued. Maybe. Yes.
That may be
after 31st March of
because why they
2021.
have only indicated February 1st.
And 31st March is the last. 2021.
And this was done on 2020.
Yes, well.
Meaning thereby that the period is ending on the 20th.
Lordship. And the appointment is also very clear, my lord. Exactly same date has been given, 22nd February to 31st March.
And if you see number 2 of the penultimate page, the last part 1 page, honorarium of the what is this education volunteer as per POA 2020-21. This is only for that week.
Yes.
So you just find out if there is anything else.
Right.
When do you have it?
Next week, if possible, I can have the inspection.
Huh?
Next week, man.
Yeah, we have it on 22nd.
Lordship.
Mr. Noor Alam, that's for you. You now have to help the BEO in fighting the disciplinary proceeding. Okay, heard Mr. B. NBP Sinha, the learned counsel appearing on behalf of the petitioner. Mr. B. Gogoi, the learned counsel appearing on behalf of the Samagra Shiksha Vigyan, and
MS Mondal on behalf of the
MS
applicant.
Mondal for respondent number.
M for applicant lordship on IA.
Is the respondent also? No.
Yes, he is the respondent. Respondent number 6 and the applicant in IA.
Respondent number 6. Mr. B. Gogoi, the learned counsel appearing on behalf of the SSA Assam, had submitted a pairwise instructions in respect to the incident matter. A perusal of the said instructions shows that the agreement is normally executed for a maximum period of 11 months within a financial year, subject to entirely the budget allocation for that particular financial year. In respect to the agreement entered into with the respondent number 6, it has been mentioned in the said instruction that the same was illegal. And there has been serious misconduct on the part of the PEO from BMC, Balijana Block, Gwalpara district, for which the authorities have decided to proceed departmentally against the said erring official. To the said instructions, there is a, no, in the said instructions, it has also been mentioned that the petitioner is otherwise not entitled to the salary from July 2021 to March 2022. In terms with the report submitted by the president of the school managing committee and HT of Konahara West Lower Primary School, which was forwarded by the DMC Gwalpara, wherein it has been mentioned that the petitioner have not rendered any service from July 2021 to March 2022. To the said instructions, the operationalization of new NRSTC centers in rural area and selection of educational volunteers was enclosed. After hearing the learned counsel, it appears that the said guidelines were specific for the year up till 2021, March 2021. Mr. B. Gogoi, the learned counsel, submits that he would also like to take instruction as to whether there is any further guidelines in that regard. To list the matter again on 22nd of March 2022. Liberty is given to the learned counsel for the Samagra Shiksha Vigjan to mention the matter for upgrading. The instructions were submitted by the learned counsel by Mr. B. Gogoi is kept on record and marked with the letter X.
I'm appearing for respondent number 5.
Who is he?
School management committee.
For
Respondent number 5.
what is that 5?
School management committee.
Oh. He has not worked.
No.
You have filed affidavit.
No.
Why?
I'll file.
No. You file affidavit, then I'll put your name. Next time you file the affidavit.
48.
Essay is wrong.
Appears for a response.
My lord, this matter pertains to refixation of his seniority as per his merit positions in the recruitment proceedings and along with his batchmates who were appointed on 2009.
Yes, CGSE. No CGC.
Mr. U. Goswami,
They have not filed any affidavit. They are not
they have filed
interested.
their affidavit.
Huh?
They have already filed their affidavit.
So then you are filing reply? No,
So I said that reply is not required at all.
not
because
required.
Yes,
Okay, we'll take it up sometime in the month of Take any great. Art Mr.
H. Bura.
8 Pedro, the Learned Council for the he submits that the pleadings are complete. Considering the above, let the matter be listed again on listed on 16th of May 2023, on which date an attempt shall be made to dispose of the matter.
Much obliged.
Yes.
Please, your lordship, this is also regarding pension, lordship. Family pension. Petitioners, petitioner's husband, lordship.
Why affidavit has been filed? Normally affidavits are superintendent of police bureau.
Yes,
Why
lordship.
they have filed an affidavit?
They, in their affidavit, they said that he has another wife, second wife, lordship.
Who?
My husband, my family pension. This is a matter of family pension. lordship.
Ah.
My husband retired, therefore expired, lordship. I applied, they filed their affidavit in.
Have you made the second wife a party?
Here, no, lordship.
Why?
Because in lordship, in the meantime, second wife filed a writ petition where there is an order to approach civil court, lordship.
Who?
Second wife, lordship, they annexed an order of this honorable court that second wife approached earlier for 50% of pension. So in that case, this honorable court passed an order to approach the civil forum, lordship.
This court?
No, Honorable Justice Jotha.
Then
In the meantime, lordship, I approached this honorable court
for
pension, lordship, because I'm the first wife and the Taiful bench judgment para 2021, lordship. I'm the surviving first wife, lordship.
Then
I'm eligible to get, lordship. He may, I don't, earlier I don't know, but now.
but would it be proper? You are just asking for
Lordship.
family pension.
Only family pension. Because
Second
my
wife,
husband,
they are bringing into the issue of family pension. They are bringing the second wife.
they are bringing, lordship.
Yes,
Saying that,
Mr. Chakraborty, why you are bringing that?
lordship may kindly see. Lordship may kindly see the order of this honorable court passed in, I mean, second wife writ petition.
Where?
In their affidavit in opposition.
Hmm.
Lordship, it starts from page 9 onwards, the relevant portion, lordship, 13, page 13, 11, para 11.
Huh? Para 13, para 12.
11,
No,
lordship.
whose petition it is, which was been dismissed? Renu Begum, who
Yes,
is she?
he's the second wife.
It has been dismissed
Dismissed and, I mean,
with liberty to the
Liberty to
petitioner to approach the civil
civil
court.
I am the first wife, lordship. They are bringing second wife, saying that they have difficulty since there is second claim, lordship. But as far the full bench judgment, lordship, I'm the surviving first wife. Even he has several wives, I don't know.
So you want that
Family
family
pension only, lordship. There are 2021 and protected, lordship.
Hmm?
There are 2021, lordship,
Huh?
of full bench judgment. I'm the first wife, surviving first wife, for family pension only.
And you are only asking for family pension,
Only family.
nothing else.
My husband retired thereafter, after 2 years he died, lordship. Expired. He was, so I'm praying for family pension.
Hello. Yes, what do you have to say?
As per our affidavit, lordship, he is the first wife of the
Admitted first.
petitioner. We admitted not.
Get it. I don't allow it. Will allow it. Huh? You pass the order later.
Diploma.
Allow kori, huh? The order to DD, huh? And their family pension will be who? You and accountant general has to be there.
Accountant general, lordship.
Who is paying for accountant general? Yes, madam is there. Put the names out there. Ticket on name. And yeah, madam, what is your name?
T. Rekha.
For Accountant General. And I don't think the directorate is required. Director pension is not required. You are paying for the department.
Department 1 to 4 lots, 1, 2, 3, 1, 4.
And
Five.
and who is paying for finance is there?
No.
No, finance is not a party lot,
Finance is not a part.
not a party.
नाम की तलुई
50.
My lord, before my friends start, my lord, we need some time to file an affidavit, my lord, because we are just handed over the recent brief.
Notice was issued on 17/6.
2 weeks time may be granted, my lord.
Last week also, last time 25/7/2022, they sought 3 weeks time to file.
My lord,
Okay. Whatever may be, what are you asking for?
Pay scale, my lord.
Very well, let him get an opportunity for
My lord.
applying. Where is the order? इकॉन किने को होते इनको होले किने के somebody have closed SM Hassan, the Learned Counsel, where is he? APDCL appearing the instructions have been received and affidavit will be filed in 3 weeks.
my lord,
That was in 2022.
my lord, yes, my lord, but
We are in 2023.
we were just handed over the file, my lord.
I hope you didn't thought it to be 3 years
So, my lord, we'll
or
file.
3 months.
Well,
Did you think it to be 3 months?
no.
Then who are you?
My lord, I'm for APDC only, my AR Borwa. Our standing counsel is Endeka.
They've changed.
AR Borwa.
The standing councils have changed.
Yes, my lord.
Earlier, who were they?
No, standing counsel, there was an order, my lord, where the files were, some of the briefs were handed over to standing councils, various standing councils.
When you are filing?
My lord, 2 weeks time will be granted, my lord. My lord, I'll leave it to your discretion, my lord.
No, I'll give you. I'll give you till April. You file
No,
till
no,
April. But file.
definitely, my lord, definitely.
It shouldn't be 200.
No, my lord.
I fix a date. Mr. A.R. Borwa.
AR Borwa.
Mr. A.K. Borwa.
Okay.
Mr. A.K. Borwa appears on behalf of the petitioner. Mr. A.R. Borwa appears on behalf of the APTCL and submits that he requires an accommodation in the matter for filing the affidavit on behalf of the respondent APTCL. Taking into account that on the earlier occasions also, time has been granted, but no affidavit has been filed from the side of the APDCL. This court fixes this matter on 29th of April. 29, no, 27, 26th of April 2023. The respondent APDCL shall file their affidavit without fail on or before the next date.
Right. Deeply obliged, my lord.
Deeply obliged.
51.
But in this case, we file a reply, that is not common record. We file reply affidavit, counter affidavit, but rejoinder, common record. Furthermore, I'm led by Mr. H.R. Chaudhary, his sister expired today, he has left the court. So
I didn't get you.
we have filed an affidavit reply, and I'm led by Mr. H.R. Chaudhary, senior advocate. His sister expired this morning. She left the court.
Very well. So what do you want?
We'll
We'll have it after 4 weeks.
That will reply be also tagged with the record.
What is the matter about?
It's regarding Granto's pay scale, pay parity sought by consumer court members. These members were appointed before the model rules came in 2020. Now they are getting very meager
Heard
pay.
Mr. M. Dr. the Learned Counsel appearing on behalf of the petitioner who submits the affidavit in reply has been duly filed today. Let the matter be listed in the on 3rd of May 2023.
52.
PPC, they were supposed to file the affidavit. The matter pertaining to release of debt, retirement, debt gratuity and retirement gratuity. the employee who was earlier covered under the NPS system, and earlier they were not entitled to death cum retirement gratuity. But by a subsequent OM issued in the year 2021.
Ad hoc
February-
grant,
Lordship.
ad hoc grant matter.
No, not ad hoc grant, death cum retirement gratuity. These petitioner, he was covered under the NPS system. And the employees who are covered under the NPS scheme, they are not entitled to death and retirement gratuity.
But there is an
That's
office memorandum.
Yes, office memorandum, he is entitled to. That is on the remark.
Yes, Lord. My affidavit has been sent for signing that. But
Why do you need the affidavit?
Not
You have an office memorandum for that,
yes, 21.
where you have thought that the government has taken a decision that people in the NPS will also be given the
It is
TR.
there, Lordship. But my instruction says, Lordship, he could not avail the DCRG benefit under the new pension scheme as per rule because he did not open the permanent pension account number, Lordship, necessary for NPS. That affidavit, Lordship, I am going to file.
When?
Lordship will take up this matter after 2 weeks, Lordship. In the meantime, I'll file. It has already been forwarded.
Okay. Mr. P. Naik, the learned counsel appearing on behalf of the PTC, submits that he will be filing the affidavit within 2 weeks from today. Let the matter be again listed on 29th of March 2023.
53.
Yes.
May it please your lordship, my lord. There are 3 petitioners, my lord. 2 of them already retired, and 1 is supposed to retire by July. They are of the irrigation department, my lord.
So we take it up after July together.
No, my lord, the pension paper already submitted before the AG. It has been returned, making a query to the.
Yes, what is your stand? Have you filed the affidavit?
Lordship, in
Mr.
fact,
P. Naik is there. Where is he? Yes,
affidavit from finance department probably is required, Lordship.
Huh?
Affidavit from the finance department probably is required, Lordship.
Yeah.
Here, Lordship, may see page 54. Petitioners, my lord, past service cannot be counted. It is there in the office memorandum already, in the notification.
What is this office memorandum?
It is the, my lord, modified assured career progression scheme.
Yes.
Page 53. It is dated 6th of July 2017. Here, Lordship will see para 10, Roman 10, next page. The past service rendered in public sector undertaking under any other state public sector undertaking, autonomous bodies, state level public enterprise or any other statutory body shall not be counted for the purpose of MSCPS. Petitioner's claim is that, my lord, it should be counted. But particular this notification has not been put to challenge. Now, by way of additional affidavit, they are impugning this, which is not permissible. They will have to amend it, my lord, by way of missioner's application.
My lord, the issue raised by the is completely in contrary to the notification issued in pursuant to the honorable court order, my lord. My lord, your lordship may kindly see. Page 54, my lord.
Page 54 only I'm looking.
Nah, page 52, my lord. Page 52.
Yes. So this is a specific order passed under Rule 31, which the governor has the power to do so.
No, my lord, their service is protected by this after this notification.
No. Rule 31 says there are 3 conditions put out there. One of the condition number 1 and 2 can be very well waived by the governor. And that is why this has been done. How can you apply this to that? You were working where?
In the irrigation department, my lord.
Of?
Initially, where is the corporation?
Which corporation?
In the irrigation corporation, Assam State, minor irrigation.
You were also working there.
Then in the year 2005, we were taken to the department itself. This is annexure or notification, my lord, kindly see. Annexure 1.
Now you were earlier in the irrigation department.
Yes, ma'am.
corporation.
Earlier we were in the
Corporation.
corporation. The corporation was
no,
the
okay.
corporation of irrigation department. Page 28, ma'am.
No, development.
262 employees were taken to irrigation department.
Now, you, how many petitioners are here?
3 petitioners.
Okay, these 3 petitioners were from this particular AMS MIDC.
Yes, ma'am. 200, in fact, 262 persons of the AITC were taken to irrigation department.
262,
These
including the petitioner.
Yes, 2 petitioners.
And here this order has been passed at page 52,
Yes,
which are 262,
yes, ma'am.
which includes you also,
Oh, yes, ma'am.
by allowing them pension and other pension in the order in relaxation of so and so, so and so, so and so. Okay.
This notification was issued after the delivery of judgment of this Honorable Court, my lord. This is also, we have annexed this judgment also, my lord. Page 56. And recently, my
Page?
lord, fortunately, my lord, we
Page,
have
page, page.
page 56, my lord. Judgment of this Honorable Court. Only after this judgment, the notification at page 52, annexure 4 was issued, by, which includes ourselves also in 262 papers.
But this is for only for pension. They have done.
Mentioned.
But have they done it for the MSCP also? Because if you see your order of 13th of May 2005, it was categorically mentioned that you are entitled to pensionary benefits as admissible under the 1969 rules.
Yes.
I think it is in consequence to that, you have been granted this benefit. Now they had to do it because otherwise you were not in government service. You see, the problem, just for example, I'm telling you about a drop teacher.
My lord,
What has happened? The problem which is arising out there, that in Jivon Dekka's case, there is a direction out there that a past service shall be taken for the purpose of pensionary benefits. Now, what happens? How do you take the past service if they were not in government service? Now, recently in Supreme Court, in 2020, has come up with has categorically stated that it is beyond comprehension. You can't take the past service for pension if they were not in government service, because at that point of time, Rule 31 did not apply. Therefore, in your case, this has been regularized by this order. You see, on 18th of November 2016. And why it is necessary, do you know this? 13th of May 2005. This particular thing was required because they must have 100% put an objection out there at that point of time. Then look here, the new pension scheme has come from 1 to 2005. So they won't get it. And that is the reason why there was this litigation to that effect. And this was regularized and made by the governor and saying that your past service shall be taken for the purpose of this. Without this order, you can't be treated as a government servant for your pension.
pension, regarding the calculation of pension, my lord, the government, AG is doing it, but your lawsuit kindly see page 69. A question put by AG asking the irrigation department.
Hmm. Hmm. But one thing, Mr. Gogoi, let us read 10. The past service rendered in a public sector undertaking under any other state public sector undertaking, autonomous to and fro, or any other body shall not be counted for the purpose of image.
Even otherwise, my lord, lordship may see their notification by which they were absorbed, page 28.
My lord, recently got a letter from the petitioner collected a letter from the AG matter, in which if your lordship is to see at page 2 paramount.
Para 1 and 4 of that, my lord, notification by which they were absorbed.
No, this is seniority.
No, even then, my lord, only for the purpose of pension, my lord, their service will be counted. Rest, my lord, including seniority, lordship will see interstate seniority to the proposed absorption against the analogous vacant post of irrigation department may be fixed below the existing respective cadre.
They have
of
already
irrigation.
retired
they will-
ordinary staff.
But is MACP for that?
MSCP is, my lord, regarding, my lord,
MSCP
a
is
common
the
employee while
person,
he is rendering service
ACP or
without any
MACP
promotion.
is the person who have been not being granted the promotion and or having no avenues for promotion.
For last 10 years, one
He
increment.
is given a higher rate every 10 years for MSCP and ACP 12. That's it.
That's it.
Now, if a person is otherwise stagnant, now that particular rule says out here, 10 says that any other public sector undertaking, if somebody works, that
Yes.
period shall not be taken.
Yes. Now, my lord,
Now,
after
Mr.
absorption,
Mr.
absorption, my
Borvia,
lord, of course,
Raj Borvia, have you challenged that rule?
The question arose on the first day of the motion, my lord, because there was a lapse on our part to challenge it. So by subsequent additional affidavit, we have challenged
I
this
think
too,
you
my
need to challenge
My
it.
lord, now kindly your lordship, I have just put the letter, my lord. Your lordship may please to see. The AG no doubt put the question. Now subsequently perhaps they have realized and they wrote a letter addressing the irrigation department. Your lordship may be pleased to see at page 2, paragraph second and third one, last 2 paragraph.
Our question is written when a government service official application But you see, why this has been granted, this rule 31 has been done, is because that is a requirement as per the provisos to rule 30. I also initially, I was not understanding You see, you are there in the old pension, new pension matters? No. Yes. You see, you have seen it in the drop teachers. In the Jiban Chandra Dekha's case, one last line has been added, the condition 6.6, which say that their appointments should be prospective, but their earlier service shall be reckoned for the purpose of pension. On that very basis, this is bypass, and it has been followed all along, that it should be given. Now the question arises, can it be given without this thing which has exercise which have been done out here? Because that period has to be treated as a government service. Otherwise, Rule 1 says, 31.1 says that a person has to be in government service. How can you count somebody's service without the governor waiving this period? Otherwise, are you not hitting on 108 where it says it requires minimum 10 years of qualifying service? Qualifying service means a service which is substantive, a service which is government service, a service where the government has paid. These are the three requirements. And this is the aspect why this was done in your case, in this case.
Other similarly situated persons, they have already been given. We have made the government in the petition, and your lordship has read the letter addressed by the AG to the government, the irrigation department, wherein it is mentioned that similarly matters are already settled. This question may not put now.
They have been given its MACP.
Yes, my lord. Yes.
Other people have got it? No.
Even the petitioners also already avail it. After they have been allowed, given us, my lord, can they now retreat from it? The very notification MSCP or SCP were there. Even then they allowed us, we have made the apartment, we have availed it. And after availing these two, we were promoted as assistant engineer. Firstly, we were junior engineer, March 2005.
But can't you challenge the rule 10, clause 10? No, I'm not touching on this petition, but can't you file also another petition or amend this? Challenging role, saying it to be unreasonable, taking into account more particularly the absorption order. Then you give this court the handle. Without touching clause 10 or saying that clause 10 should be given a benefit to the effect that these people have been working all along and the benefit of 31 has been given to them and has to be read as giving something. But how does this court give you this relief?
We have to file the additional affidavit.
No,
which is
Mr.
considered.
Rajbal,
Otherwise, you shall have to amend it.
I would have understood if somebody else had stated that you do a lot of civil matters also.
So we will amend the petition.
Huh?
We will file an amendment.
I think better of you need to amend it. Otherwise, this will be the problem. But anything, it's this particular document at page 52 gives me a further better understanding of the judgment which I am preparing for this old pension, new pension. You keep this. Heard Mr. N.H. Balhuia, the learned counsel, Raj Balhuia, the learned counsel appearing on behalf of the petitioner. Mr. B. Gogoi appears on behalf of the finance department, and Mr. N. Upadhyay appears on behalf of the irrigation department. The learned counsel submits that some time may be granted to him so that he can file an appropriate application seeking amendment of the writ petition or file another writ petition challenging clause 10 of the notification dated of the MACP scheme dated.
There are two notices. One is ASCP, my lord, another is MSCP. That is, MSCP is.
We are concerned.
6/7/2017.
6/7/2017. Taking into account 4 weeks time is being granted. Okay.
61.
Orders no. Orders no any. Yes.
Please, Lordship, my lord, the personal department filed the affidavit today, my lord. It's up to me, my lord. I'll, if required, I'll file my lord reply. Maybe fix on my lord 23 or 24th, my lord. Because-
For what 24?
Because examination 26, my lord.
No. Oh, that matter.
My lord.
So the total post in the cadre was 86. We have stated something, therefore has challenged the state after here. Oh. Now, what do they say?
My lord, they are saying that they have, they have provided, my lord. They are
No, it's
saying that,
okay.
my lord,
We put it on some other occasion, but I think there is some urgency.
my lord, except appearing in the exam before declaring also, it, my lord, close the matter. I have nothing, my lord.
No, there is no interim order in this case.
No, my lord.
Under such circumstances, wouldn't this lead to a lot of problems later on?
Then maybe 23rd or 24th, my lord, of month. 26 is exam.
26 is the exam.
Exam, my lord.
We fix it on 22nd.
My lord, 22nd I'll be, my lord.
Huh?
22nd, my lord, I'll be in somewhere, Supreme Court, my lord, one criminal.
But then 24th,
My lord.
let the matter be listed on 24th. It has been brought to the notice of this court that the respondent number one have filed their affidavit
Today.
in the position.
We have filed today, my lord.
I filed the affidavit in the position today.
My lord.
The same be brought on record by
24th.
63 for order.
Yes, what do you want?
My lord, this IS filed for correction of respondent number 1, 2, and 3.
For what?
Name and designation in the post title.
Huh?
In the post title, name and designation is wrong.
Name of the cause title in repetition in what do you want to put?
My lord,
Tell me, what do you want to put?
my lord, it was earlier
And unnecessarily, further response has been unnecessarily impeded who has no connection with the relief. For release of the legal dues such as leave encashment benefit, gratuity and area salary as per the calculation. But in impeding the respondent due to some technical update, method and office and designation of someone who has been controlling has been incorrectly mentioned. Now, what has been, what is wrong?
my lord, the designation of the respondent number 1 was represented by the Commissioner and Secretary to the Government of Assam, Plains Tribes and Social Welfare Department, Dispur 46, and it would be represented by the Commissioner.
Mr. Counsel, why have you not mentioned what are the changes you want?
My lord, the second portion we have mentioned.
You have not stated what are the changes you want.
My lord, in the page number 3, it is
I've read your page 3, 4 and all, 4, 5.
corrected portion is the
Hey, Pani, it should be here tribal affairs.
yes, ma'am.
You are there.
I
You have no problem with this, no?
Oh, my lord.
Branch manager, it should be managing director. Mr. Counsel, you can't correct this manner. How can I allow it?
It will be easier if they withdraw and file a fresh one.
No, but you have to do something, no? He has been delayed for all this time. You withdraw with the liberty to file a fresh one.
We'll file another, I
It's the same thing.
will mention,
Mr. Counsel, why you are not filing a fresh writ petition? Making the correction, you file an IA. Once that actually this IA is not done properly, you want to file, you want to put the names wrongly. I would have understood if any order, in fact, this case notice has also not been issued.
my lord, liberty may be.
Yes. I cannot read petition. The learned, heard Mr.
M.H. Ali.
M.H. Ali, the learned counsel appearing on behalf of the petitioner, and Mr. R. Dhar, the learned additional senior government advocate. On 16/12/2022, the learned senior government advocate, additional senior government advocate had informed the court and had apprised this court that there were various defects in the writ petition. In mentioning the names of the respondents. In pursuance thereto, the learned counsel appearing on behalf of the petitioner have filed the accompanying interlocutory application making certain changes, seeking certain change to the names of the parties. The learned counsel for the petitioner submits that instead of pressing the two applications, he would withdraw the the writ petition, and he may be given the liberty to file a fresh one after making the necessary corrections, after removing the formal defects. Taking into account the same, the instant writ petition stands dismissed on withdrawal. However, liberty is given to the petitioner to file the writ petition afresh by removing the formal defects as regards formal defects. Taking into account the order which has been passed in the accompanying writ petition, the instant application also stands dismissed as being not pressed.
64.
You file it properly. Last thing.
Matter pertaining to my lord for granting compassionate my lord
Family pension.
To the petition.
Yes, madam.
Lordship, we have already written a letter to the department, but we are still awaiting instructions. Another 2 weeks.
Which
time may be
department?
granted. PHE department, Your Lordship.
Madam, why is the problem with PHC? PHC means they don't feel like complying or instruction doesn't come. What is that full form? Public Health
Public Health
Engineering.
Engineering.
What do they do? Yes, tell me, what do they do? Yes, you are working there, na?
Yes, my lord.
What do they do? PHE?
PHC, my lord, for supplying water, my lord.
Oh, water supply.
Yes, my lord.
Okay. That is why in Guwahati still we don't get water.
What?
It's a difficult department, Your Lord.
Huh?
It's a difficult department.
Difficult department.
Instructions do not come.
Now, when do you want it?
2 weeks time may be granted.
For what?
For the inspection.
This is a case for not granting the compassionate family pension. You are regularized.
Yes, my lord.
Huh?
2005, I am regularized.
Oh, unfortunately, he died.
Yes, my lord. On the ground that.
Miss, what is your name
M. Kalita, your lord.
and your name?
M. Kolita, my lord.
Both.
Mr. M. Kolita.
Okay. Heard Mr. M. Kolita, the learned counsel for the petitioner, and Miss M. Kolita, the learned counsel appearing on behalf of the PhD department. Ms. M. Kolita, the learned counsel for the PhD department, seek for an accommodation of 2 weeks, 3 weeks, to obtain the instructions in terms with the order dated 10/2/2023. Taking into account that the petitioner, the petitioner, the husband of the petitioner had expired as far back as on 10/3/2018. And till date, there has been no payment of any compassionate family pension. This court fixes this matter again on 31st of March 2023, on which date the respondent PhD department shall obtain the necessary instructions in the matter. It is observed that if the instructions are not obtained and or affidavit is not filed on or before the next date, this court shall proceed to determine the instant dispute on the basis of the available materials on record. Liberty is given to the petitioner to mention the matter.
Highly up.
After a long time, I finished my list.
দেখা তুমি যে রিট পিটিশন বানাবা